Supplementary list, fresh admission, item number 1.
My lord, this matter has been, I am engaged as amicus curiae, my lord, in sub-item 2, my lord, in JCRL 40 of 2019. And this matter has specifically fixed to 11-8 before my lord Justice S. Talapatra and M.S. Shah, my lord.
Plus 2 jail criminal appeals have been prepared by the same appellant.
I see. All right. List all this appeal as well with JCRLA 40 of 2019 on
11-8
11th August
2020.
22 before the bench of Justice Kalapatra. All right.
Supplementary list, item number 2.
Okay.
May I please, madam? The petitioners are the villagers of the Chhatia Gram Panchayat in the district of Jajpur, being aggrieved by the illegal activities of the land mafias for illegal construction in the Gochar land. They have preferred this PIL ballot. There is a
Who are the land mafias, sir?
that they are implied as opposite party number
5, 6, and 7.
Yes, madam.
So you have a representation.
Yes, madam.
Where is that?
At annexure
6 and 7, page 30,
Ah,
31.
petitioners' representations, bracket annexure 6 and 7 shall be examined by the collector.
yes, madam.
Jajpur, and after issuing notice to the petitioners as well as
And it
opposite
is
parties.
addressed to Tahsildar Darpan. Annexure 30, Annexure 6 at page 30.
So we'll
Addressed
ask the
to,
Tahsildar to look into it.
yes, madam.
Or
Tahsildar
Tahsildar
Darpan.
Darpan, and after issuing notice to the petitioners as well as opposite parties 5 to 7 and giving them a hearing, a reasoned order shall be passed not later than 19 September 2022. And the copy of the decision shall be made available to the parties within a week thereafter. The court clarifies it is not expressed any on merits. Petition is disposed of.
Supplementary list, item number 3.
May I please, your lordship? There are there are, my lord, 3 matters it has come. In fact, the present writ petition is a sequel to the order passed by your lordship in WPC number 6486 of 2010. With your lordship's kind permission, I beg to place little background of the case. And there were portions of DT's properties in front of the houses of the petitioners and some of the predecessors of the petitioners, because they have been substituted in the meanwhile. Now, the endowment authorities found that the land is not yielding any result, so it should be disposed of. Way back in 1988, application was made by the, my lord, opposite party number 3 before the Land Commission of Endowment, praying for permission to dispose of the land in question, that is the sub-collector cum executive officer, and it was allowed. It was allowed, fixing the land value at rupees 1,65,000 per acre. And for trees, it was fixed at rupees 1,000. Now, a suo motu revision was initiated by the opposite party number 1, and it was modified to 2 lakhs. So far, the value of the trees are concerned, it was kept intact. Now, thereafter, though we deposited the amount in time, my lord, the executive officer did not execute the sale deed. Realizing his mistake, because opposite party number 4, the Learned Assistant Commissioner of Endowment, paragraph 9, page 10, your lordship will kindly peruse, sought for an explanation from the executive officer as to why it was not done. Thereafter, he files an application for extension of time. That was rejected, appeal was preferred, then the many proceedings were initiated in the revision, also miscase was filed, that got rejected. And ultimately, they issued a notice for payment of money on the current market value. That is what it was challenged before this noble court in WPC number 6486 of 2010. When this matter was taken up, I made a submission on instruction before your lordship that the petitioners are ready and willing to pay at the current market value. Your lordship will kindly see the phraseology that has been employed by your lordship in the order itself, current market value, present market value, and on the basis of that, the matter was disposed of. Now, despite the fact that your lordship's
Which
direction
is that
was,
order?
and that is
Your Lordship, WPC number 6486 of 2010, that has been
No,
disposed.
order dated.
Order dated, Your Lordship. Yeah, I missed it. 2022. Man, pursuant to the direction of this noble court, instead,
One.
I have quoted it in page 14.
Hmm.
Now, they constituted a committee. Here's the direction of this noble court, that is, Your Lordship will find at page 16, paragraph 21, they included many other persons who are not parties to the proceeding. In any event, the valuation of the land was fixed at rupees 4 crores, despite the fact that a report was submitted by the sub-register, who is the competent so far as the valuation of the land is concerned, to the effect that the land valuation is 1.80 crores, which would be enhanced to 2.20 crores with effect from 1/4/2022. That is 1st of April 2022. We agreed that yes, we are ready to pay at the rate of 2.20 crores also. We have no grievance.
No, you're
Now
you're questioning the valuation itself.
Yes.
Yes, my lord, because there is a modality provided in the statute, namely in the Orissa stamp rules, there is a committee in place which also takes into consideration the market value of lands and decides and recommends which is approved. Now, they thought it proper to include the sub-register and report was called for. Sub-register says it is 1.80 crores per acre before 1/4/2022. Post facto 1/4/2022, it is 2.20 crores. Now, without mentioning anything, the committee decided it is 4 crores. That was challenging for this. Now, let me just clarify. One more sequence is there. Just let me.
Your prayer is very limited. There is nothing to say.
If my lawyer senior will not allow me to even
No,
just
allow.
assist your lordship,
I don't disagree. I say that your prayer
sorry,
is
madam,
limited.
just
Your prayer can be allowed.
4 or 5 lines more, my lord. May I not be permitted to, my lord?
All right.
Then what happened, my lord? I challenged that for this noble court in WPC number 8394 of 2022. Possibly that file has not been placed before your lordship today, but this noble court, taking note of the fact that your lordship's specific direction was to the opposite parties and persons who are not parties to the proceedings have been included in the committee, and the fact that the decision with regard to 4 crores was taken without any material. Your lordship will see the observation of the
1 minute.
I have quoted the order of this noble court in the earlier writ petition at page 17, paragraph 23.
Right.
With your lordship's kind permission, may I just place it? It's a small paragraph, my lord. Having heard learned counsel for the parties and after perusing the record, it is clear that as rightly contended by Mr. Mishra, the learned counsel for the petitioner, that no region has been assigned by the committee for reaching the figure of 4 crores per area when the district valuation committee had suggested enhanced valuation at rupees 2.2, that is 2 crores 20 lakhs per acre. Apart from that, the impugned order at Annexure 5 also does not show that the valuation which was ultimately decided by the committee to be present market value vis-a-vis the land involved in the case. Lastly, it may be noted that this court had directed the opposite parties in WPC number so and so to calculate the amount on the basis of present market value vis-a-vis the land in question. In the instance case, there is nothing on record to show that such an exercise has been undertaken by those opposite parties, who are opposite parties 1 to 5 in the present writ petition. On account of all these reasons, the decision taken by the committee at Annexure 4 on 8/3/2022 being result of an arbitrary exercise of power is legally untenable. Accordingly, the same is set aside. In tune with the earlier order of this court, the opposite party 1 to 4 are directed to take a decision in accordance with law with regard to the present market value of the land involved in this case by 22/4/2022 and communicate the same to the petitioner number 20 on the very same day, who in turn is directed to share such information with other petitioners so that they can make payments by 25/4/2022.
They repeated the decision within 2 days.
My lord,
Within 2 days, they again decide it's 4 crores.
decided. Now, my lord, this noble court in the earlier writ petition, which I was just read out, was pleased to point out that this phase 4 crores is based on no material. Now, your lordship may kindly see the impugned order that has come to existence. And before that, may I just, with your lordship's kind permission?
No, but what's your prayer in this application?
Exactly.
Prayer is with regard to the valuation. I have challenged.
No,
To extend the time limit.
Extension of
No.
time.
There are two. In fact, I'm sorry. I'm placing the writ petition that extension will be a sequel to decision in WPC number 11201 of 2022.
That is not right.
That is
No
that is before
copy
your
has
lordship.
not been served. That is not the
The only
list. That is
application
why
we
I am
have is
submitting.
extend the time limit fixed by the.
Exactly.
No, that is because just let me
Only the
clarify.
IA is listed, I
And
think.
let me just clarify. All the records are before your lordship. Why this matter was the WPC number 11201 of 2022 was called for by your lordship on my submission. That is because the time limit extension with regard to payment will be dependent upon my challenge to the valuation they have fixed afresh in WPC number 11201 of 2022, which is before your lordship on board. That is on your before your lordship. The third item your lordship will see. Third item. So therein, prayer for extension of time would be made depending on what your lordship will decide in my writ petition, where I have the fresh valuation I have challenged. I will demonstrate from record that as per the rule 38 and 39 of the Orissa stamp rule, which provides for constitution of a committee, and now by virtue of amendment of the year 2020, the approval of the Board of Revenue is to be taken, clause C has been amended, that the committee has to take data and decide the market value. Here the sub-register, on the basis of that committee report, says that the valuation would be 2.2 crores from 1/4/2022. Not only that, now the present decision, which has been taken by the opposite party, which is being impugned in WPC number 11201 of 2022, I will demonstrate no document has been referred to, though my lord, the sale deeds I have annexed under annexure 5 series, which are of recent origin of same Mauja. My lord, the valuation is maximum up to 2.2 crores. I have annexed the sale deeds because the sale deeds will indicate. I have annexed.
But they pass a detailed minutes, page 46, 47.
Yes, I beg to demonstrate. Read out that to assist your lordship. Page. Yes, my lord. Page 129. Your lordship may kindly see.
Anyway, it's in the new writ petition, it's page 46. 129 is an earlier letter. Annexure 4 is the new one.
I'm sorry.
Annexure 4 at page 46.
Deeply obliged, man. Deeply obliged.
If will permit me, I will take only one subject to permission of my learned friend.
I'll not grant permission.
Yes, you please grant me. If my learned friend is pressing WPC 11201 of 2022, which is challenged the filed against that order, no copy has been served on me or the counsel for the endowment commissioner, although it is listed.
No, copy diya hai.
No, that is not there. So let him give the copy and we will file counter to that. And extension, your lordship can extend the time period.
Now, extension will be depending on this, so it may be kept.
So notice can be issued in
That is obvious. That is what I'm saying.
11201 of 2022 is a notice. Mr. Manti accepts notice for opposite party numbers.
You give the copies right now to him and me.
My learned senior will take only for
Defect
one.
number 8.
1 and 5. 1 and 5.
Number 8.
1 and 5.
Copy not.
And my friend is there for 2 and 4. 2 and 4, my friend Mr. Nath.
Mr. Nath accepts for 2 and 4.
And for 3, my friend Mr. Mishra is there.
I will
Mr. accepts for 3. Replies be filed within 4 weeks, rejoined up to the next date.
That extension is subject to result of the
Yes,
second.
that is what I have submitted.
That is quite obvious.
I have submitted.
Correct. List on 22nd September.
Obliged.
The in that IA number 5504 of 22 in 6486 of 2010 is a notice. Again, all of them accept notice. List along with.
May I pray the WPC number 8394 of 2022 may be also called for so that your lordship can produce it.
That is
WPC
tagged. That is tagged.
Okay, list along. No, the record of
WPC number 8394 of 2022.
Yeah, record of 8394 of 22, we called for the next.
Disposed upon 19/4/2022.
Correct, correct.
Deep localized.
Supplementary list item number 4.
Item number 4, Lordship, sub-item 1, I have filed application for amendment, which your Lordship was pleased to direct the respondent to file counter. Lordship, that amendment all matters are
What is the IA for amendment, sir? What's the IA number?
IA number 1144 2020.
That's not shown on the list.
Already 3-4 months back, before last listing, Lordship was pleased to issue notice to opposite party to file counter for amendment. Amendment is only
No, where is the IA? We don't have the IA.
Lordship.
Where's the IA number you say?
Have been urgent to the month of
16/11. Is it there?
16/11.
16/11.
Ah. Mm, 1144. So if we allow this amendment, what happens?
Lordship.
The amendment copy has also not been filed.
Already I have supplied. That day I have supplied the amendment copy. That day in the court I have supplied. Lordship, pursuant to my lord's direction, immediately I
17th
supplied in the court to my MK Khuntia, who appeared on that day.
Okay, all right, my lord, that has been solved to the.
Where is that 17th? No, it was not listed on 17th February. After that, October 21, it has not been listed.
It is not been listed.
Oh. All right. One IA 1144 2020, another copy of this IA be served on counsel for the opposite parties. 1 and 2 today itself. November 29th.
Supplementary list item number 5.
May please, madam. This matter relates to the challenging of the virus of notification that 2004 granting order. Madam, similar such type of similar matters is posted to 16/11/2022.
In all cases, my learned friend is not serving copy on the state.
I will serve. Madam, tomorrow I will serve.
Notice, Mr. Madali accepts notice on behalf of
Madam, today I will serve.
opposite parties 1 and 2. Notice to opposite party number 3, returnable 22nd November.
Madam, 16/11/2020.
16 November. All right.
With along with the WPC number 8960 of 2020.
All right. List along with 896020. All right.
Obliged.
Supplementary list item number 6.
May I please, your lord. Where, my lord, without, my lord, following the provision, my lord, the guideline issued by the central government as well as state government, the open tender has not been floated. And my lord, the work that assigned to the Orissa Construction Corporation Limited, my lord. The work is the reimbursement, maintenance, repairing work of the Hirakud Dam, my lord. I am the experience holder that, my lord, the ISO certificate as well as, my lord, the Orissa Small Industries Corporation under we are also included. My lord, I am worked since 2012, my lord, 2020. This is different works I have assigned to in the Hirakud Dam. Though, my lord, the central guideline, your lordship may kindly turn to the page 70, annexure
So this
9.
is February 2022 tender.
Yes, tender has not been floated, my lord. Directly assign the work to the Orissa Construction.
Whatever, sir, this happened in February 2022.
Yes, but till date, my lord, the agreement has not been executed, nothing.
No, but you waited for 3 months to file a writ petition.
So lordship may
State government work and it is being executed by a state government undertaking,
Oh, I
not
see.
by any private party.
Oh, I see.
no, because, my lord, previous year they have been floated tender, but it was this year, this, my lord, they directly assigned to the work to the, my lord, Orissa
They are
Construction
entitled
Corporation
to
Limited.
do that. What is wrong with that?
So therefore, my lord, the other there, my lord, what I'm saying, my lord, Orissa Corporation, Orissa Construction Corporation had not, my lord, experience at all, my lord. The, my lord, first time work are assigned to, because the responsible work of the Hirakud Dam is the big dam, my lord, the responsible work. Therefore, my lord, I am also worked in several time in the Hirakud Dam, my lord.
So what?
So
Doesn't
Lordship,
mean that you have
therefore,
monopoly there.
without, my Lord, following the guidelines issued by the Lordship, for a moment, my Lord, the page 71, the central government guideline, Ministry of Micro, Small and Medium Enterprises Office Development Commission, MSME, that has been, my Lord, 2012 guideline. They are, my Lord, mandatory procurement for micro, small and enterprises. They were, my Lord, they shall be given to preference to the micro, small enterprises at 20%.
That
As
is,
well
if
as
they're
state
giving it
government
to
also.
private parties, they'll give preference. If the state government undertaking itself is doing it, then there's no question of
So
preference.
therefore, my Lord, also state government, my Lord, there also been issued, my Lord, resolution.
That notification is applicable to only central government, its departments, as well as its undertaking, not to state.
No, state government also
Page-
notification
page
has been issued, my Lord.
Page 70 makes it clear.
No, my Lord, page 79, that's the state government guideline also. My Lord, the Orissa procurement preference policy for micro and small enterprise 2015. Here also same, my Lord. The 20% should
It's
be
not
given.
mandatory, sir. If they go in for a public tender, then it's possible that they will give you preference. But if they're allocating it to their own corporation, there's no question of this.
Because, my Lord, I have also represented before the authority, my Lord. They may be decided, my Lord, because the work has not been started.
Where is the representation?
My Lords, my represent Annexure 7, my Lord, page 57. But you got it? Yes,
But the work has already been allotted, no?
Yes,
allotted, but it was not,
Allotted and
work
it-
has not been started,
they have
no
also
agreement has been
accepted.
executed till now, my Lords.
they have also
I will stop,
accepted. Page 56 is the acceptance.
Oh,
No, accept, but your Lordship, till date work has not
no,
been.
this
my
will
Lord,
upset the whole thing, sir. Sorry.
Yes.
The work in question has been allotted to the Orissa Construction Corporation Limited, which is a government of Orissa undertaking. Consequently, the court is not persuaded that there has been any violation of the guidelines which require preference to be given to small and medium enterprises, as that would have come into play if the process had been initiated, process of award of tender had been initiated by any public tender. Full stop. Consequently, the court is not persuaded to interfere. The petition is dismissed.
So may only, my Lord, the refer to the opposite party, my Lord, therefore the Annexure 7, they may be decide, my Lord, if the
No,
tender
no,
has
sorry.
been.
Supplementary list item number 7.
That's great, my Lord.
My Lord, OP number 6 to 30 are the encroachers. And for the removal of the encroachment, representation is addressed to the collector Annexure 5, page 23. I pay, my Lord, after hearing the perusing the documents and hearing the parties, collector may.
What is that to show you served the representation?
My Lord, Annexure 5, page 23.
Sir, please listen carefully to the question. What is there to show that you have served this Annexure 5?
My Lord, physically, we.
That's not how it happens, sir. You make a fresh representation, permitting the petitioner to make a fresh representation to the authorities, and after following up on such representation, to seek appropriate remedies in accordance with law, the petition is disposed of.
Supplementary list item number 8.
Please, madam. In this case, OP number 6 to 13 are encroachers on Gochar land, my lord.
Annexure 2
In that
series.
regard,
Has that been served?
petitioner has filed the representation at page 19, my lord.
Have you served that representation?
Yes, my lord. At page 20.
All right. Petitioner's representation Annexure 2 series shall be examined by the
No, it is addressed to Revenue Secretary, nothing. Maybe Tahsildar, concerned Tahsildar.
Tahsildar Kyonjar, and after issuing notice to the petitioners as well as opposite parties 5 to 13, and after giving them a hearing, the reasoned order shall be passed thereon not later than 19th September and be made available to parties within a week thereafter. The court clarifies it is not expressed in review on minutes. The petition is disposed.
Supplementary list item number 9.
May it please your lordships. Lordships, after the judgment of the Supreme Court in Ashish Kumar Agarwala's case, the revenue invoked the new provision as which came into force. That is 148
AB.
small b.
Yeah,
That is Annexure 1 at page 20.
correct.
Now I'll show the reason which compelled them to, which has been, for which this notice has been issued for reopening. Lordship will see the reason, information stroke material relied upon during the financial year 14-15, relevant to the assessment year 15-16, the assessee claimed rupees 125 crore 2710.
Anyway, you replied to this or not?
Yes, I have replied, but your Lordship will, I'll just take your Lordship's 2 minutes time. I'll not waste more than 2 minutes. This particular issue, that is repayment of loan to the bank for the charitable purpose, has already been decided by the appellate authority for earlier years as well as by the tribunal. Now I will take your Lordships only to the appellate order's finding. Lordship may kindly see that finding of the appellate authority, which your Lordship will find at page 72. And this apex court, in the case of Radhaswamy Satsang case, that is 1992, page 321, 193 ITR, by Justice Rangnath Mishra and Kuldeep Singh. They held that strictly though res judicata is not applicable, but if the parties have acted upon the same and new facts do not permeate, then the reopening cannot be done. I'll also supply those judgments of the Supreme Court. Now, your Lordship kindly see.
We have not reached the stage of 148 notice yet.
Yes, yes, they have issued.
Where?
They have issued 148A.
No, sir. After 148A,
yes,
they'll file. You file a reply.
Yes, they have rejected it. I'm submitting it, my lords. Affidavit. I'm submitting it.
Where is that?
Yes, I'm submitting that by way of affidavit.
No, but after they reject, they will issue a 148.
No, yes. After they have rejected, I'm on that only.
No, but everything can't be, sir. We'll have so many tiers of adjudication then. The point is 226 will be an endless thing.
No. Lordship may kindly see.
Let them issue a 148 after this and we'll see.
148, my lords.
They will now issue, sir, after this 25th July late order.
Now, your Lordship will kindly see.
The last line must be hereafter.
Yes, 148. Now, my lords, just Lordship may kindly see. Kindly, your Lordship may give me 2 to 3 minutes. My lords, what I emphatically assert that this particular issue has not only been decided by the appellate authority, by the tribunal, as well as by this honorable court. And this honorable court, Lordship will kindly say, did not interfere with the when this revenue file appeals. Lordship, I am submitting I'm submitting, my lords. This is totally, my lords, the invocation of jurisdiction on the self-same issue, that is 148A capital B, has been decided by the tribunal, by the first appellate authority for the assessment year 11-12, 11-12, and by the court. This honorable court did not interfere. They said that no question of law arises. Lordship, for a minute, will kindly see the order of the tribunal. I have also, my lords, the tribunal being the last fact manager, my lords, every year this will continue then. And they will invoke 148A. Lordship, may I think, I don't...
let the 148 be issued. We're not expressing any view in the matter. We're leaving it all your contentions open. Let them issue a 148.
No, 148, my lords, the difficulty is that, my lords, Lordship will kindly see. No. Say jo affidavit ta diyo. 148 is the issue, my lords. And second thing, my lords, I think your Lordship will agree that there is a statutory prohibition so far as the limitation is concerned. And I think I'm not able to persuade your lordships. This is a bad day for me.
No, no, why is it a bad day? More petitions is good day.
Lordship, may I kindly see?
Yes.
May I take your lordships to section 149B?
All right. Come back.
The whole limitation 149B, which came into effect from 142021. Lordship will kindly see 149B that they
More than 10 years.
If 3 years, but not more than 10 years have elapsed from the end of the relevant assessment year, unless, Lordship, that is the catch, unless the assessing officer has in his possession books of accounts or other documents or evidence which reveal that the income chargeable to tax represented in the form of asset, and this is the assessment year 15-16. Where is your allegation that this escapement is in the form of the asset? Therefore, I am invoking 148A. Where is that? This is totally, my lords, absent from the allegation. Lordship, have a look to Annexure 1.
Yes.
At page 2021, my lords. There is absolutely no allegation that this represented, and assessment year is 15-16. 3 years have elapsed. Now you want to invoke 148A, and you are not writing that this has escaped.
No, page 21, second paragraph.
Second paragraph, yes.
The assessee has claimed.
Has claimed
119 crores.
the cost, yes, the cost of fixed assets.
Yes.
Yes, the cost of fixed assets, purchase of building equipment, etc. Although the fixed assets were acquired through bank loans,
Yes, yes.
then it was noticed that the assessee has availed bank loan. This is important, my lords,
Yes.
of rupees so and so during the impugned year. In C itself, mostly for building and equipment. Where is your allegation that this represent in the form of asset?
Right.
And therefore, I have got reason to believe.
All right. All these we leave it open to you to urge, sir. We leave it open to you urge.
My lords, after all, I have.
There's no end to 226. You'll come back.
I know your lordship is overburdened.
Not
and that is why your lordship is.
No, I know this is the new sluice gate. If I open this gate, Mr. Kara is waiting. There's a whole host of people waiting.
No.
Yes. We just disposed of 250 matters the other day. Each of those 250 matters have given birth to new notices. So those will give birth to more writ petitions.
Another 250 cases will come.
No, man, that is not the question is, my lords.
Yes.
At least.
No, we are anyway going to have petitions filed after the 148 is issued.
My lords, 148.
Yes.
Once 148 is open, my lords.
Then then again one more round you have.
My lords,
You have one more round. In 148 you will file a reply. You'll file. It's like you have now crossed the GK and F sharp stage.
Correct.
Now you will come to that actual reply to 148.
Correct. Correct, my lords. I bow down. I know that this today I cannot. From the beginning, I have already guessed your lordships. But the question is, my lords.
Yes.
Lordship will agree.
Yes.
After all, your lordship will agree. I know your lordship will not hesitate. Your lordship has, to that extent, lordship has been so fair enough.
Yes.
Well, as lordship will agree
Yes.
that in the notice under section 148B.
Yes.
Okay, my lords, there is no allegation
Right. Right.
that this represented in the form of the asset.
All
So where is the question of 148?
All right.
My lords, that is, and your lordship, one more thing, my lords. I think I am failing today.
No, please make your point.
My lords, lordship will 148, after 148,
Yes.
what can I do, my lords?
Yes.
I have to, now the scope is rather, my lords, so far as this 148A(B) is concerned,
Right.
lords will kindly see the date of the notice. Lordship, for a minute, kindly glance. It is in the month of May,
Correct.
22/5,
Correct. 24/5.
24/5.
Correct.
And I challenge before this honorable court on earlier years, and in the WPC 44, that is 4669 of 2022. This honorable court on 11/7 disposed of the writ petition in the line of Ashish Kumar Agarwala.
Right.
But before that, a stay was continuing till that date.
Mm-hmm.
Now, without awaiting the decision of this honorable court, they have given this notice 148A(B), that is 24/5/2022.
Right, sir.
And when the stay was continuing, my lords, so I had no chance of the personal hearing, my lords. The hearing which is fixed to 10th of November 2022. And I gave the reply. That reply, my lords, was considered unilaterally without affording an opportunity for hearing.
All right.
So, my lords, at least before the disposal of my objection, what in other writ petitions,
Yes.
where your lordship have posted it, that whether,
Have you taken that ground here?
no, I have not taken.
Then
To be fair enough,
then fine.
I'll find that. I'll amend it and take that. No. At least your lordship will not deprive me from that. I know. At least your lordship will
Chimanka will
not.
not object.
Huh?
Mr. Chimanka will not object.
No, he is a formidable opponent.
No, to your plea for amendment, I will not object.
Yeah, I'll file an amendment application.
All right. Mr. Rai states that he will move an application to amend the writ petition to add a few more grounds and also bring on record this. Okay, this affidavit will already take on record. So the affidavit placing on record the order dated 25th July 2022 is of the assessing officer.
Yes.
Yeah, it's taken on record. Then you say Mr. Rai states that he wishes to amend the writ petition to add a few more grounds at his request. List on whichever dates it will then.
Sir, next week, any date, I'll file the amendment application.
All right. 3rd August. 3rd August.
3rd August. My, why I'm afraid, my lords, of Mr. Chimanka, immediately, my lords, they will proceed 148 and also, my lords, start assessment.
No, it's all right. Why should you be afraid, sir?
There will be one more exercise, my lords.
It's a good lesson for young lawyers watching today how to get out of a ticklish situation.
Thank you, my lords. Much obliged.
All right.
Much obliged.
All right.
Supplementary list item number 10.
It's Mr. Rai's ingenuity, my lords.
Yes,
May I please, my lords?
yes.
This petition, my lord, is the entire proceeding, my lord, is initiated against a dead person. And orders are passed. Your lordship would see,
Correct,
my lord,
correct,
the
correct.
date of death, my lord, is 6/10/2021, my lords.
Yes.
That's an annexure. My lord, at page 38, I've given the death certificate, my lord.
Right.
And the notice of 63, my lord, is 29/11/2021, my lords. After death, my lords.
Right.
And thereafter, the order is passed on 4/2/2022, my lords.
Right.
My second humble submission, my lord, would be if your lordship would kindly turn to annexure 2 at page 36, my lords.
Yes.
This particular assessee, the husband, my lord, of,
Yes.
of the present petitioner, my lord,
Right.
he was assessed in a limited scrutiny assessment, my lords.
Right.
Now, your lordship knows that this limited scrutiny was only for finding out about the high value cash deposits in his accounts, my lords. Bereft of the fact, my lord, that this was completely, my lords, examined by the assessing authority, the persons who had deposited or who has given them, they were examined, my lord. 133(6) notices were issued, my lords. Now 263 proceeding has begun, my lords. Lord, I'll just place at page 36, if your lordship will kindly permit me, my lords.
Yes.
5 lines from the top. I'll begin with this case.
Yes.
This case was selected for limited scrutiny assessment under CASS with the reason of high value cash deposits during the financial year 16-17 to compare to the low return incomes. On the basis of AIS information, it is observed that there is a cash deposit of rupees so-and-so in account number so-and-so maintained in SBI High Court campus, Cuttack, and 50 lakhs in account number so-and-so maintained at Corporation Bank, Kacheri Road, Cuttack. Statutory notice under 143(2), 142(1) of the Income Tax Act was issued online on e-proceedings and ITBA. In response to the said notices, the assessee furnished the required information, documents as called for by those statutory notices, which were verified for the purpose of ascertaining the source of the mentioned cash deposits. From the documents furnished by the assessee, it is evident that the assessee has claimed in his reply that the total money deposited in the above amounts are the monies received from the clients for selling flight and train tickets as agents. Lord, he's a travel agent, lords. For traveling companies like
Anyway,
Mrs.
1 minute. You want to file a reply or we can dispose it off?
The Principal Commissioner of Income Tax passed order non-compliance assessee. Let him
What has happened, Lord?
No, the same dead person, sir. There's no him now. She's the wife of the person to whom you issued the notice. The person died much before you issued notice.
Notice has also the result, my lords, of the.
So the initiation of proceeding itself is suspect, sir. So should we dispose it off or
dispose?
Or, my lord, the second point may kindly also be considered, because there's no fresh material for 263.
No, but let them first issue you a notice, then you can urge all that.
Yes. Then your lordship will quash this annexure.
Yes. You say the short ground on which the petitioner prays for quashing of the show cause notice dated 29th November 2021, issued by the Principal Commissioner of Income Tax, Bhubaneswar 1, under Section 263 of the Income Tax Act 1961, for the assessment year 2017-18, issued to her late husband, is that by the time the said notice was issued, he had already expired. She has placed in record, full stop. She has placed in record the certificate of death issued by the Department of Health and Family, by the Cuttack Municipal Corporation, which shows the date of death to be 6th October 2021. Paragraph. Not only was the notice proceeded with, notwithstanding the above fact, but on 4th February 2022, even a revision order has been passed against the same person, that is the late husband of the present petitioner. Paragraph. Mr. Chimanka, learned, it's a notice, Mr. Chimanka accepts notice. Paragraph. The fact that the notice was issued and an order was passed against a person who had already expired by the time the notice was issued is unable to be disputed by Mr. Chimanka. Consequently, the court has no hesitation to hold that the entire proceeding stands vitiated. Consequently, the impugned show cause notice dated 25th November 2019
29th.
and the consequent revision order dated 4th February 2022 passed by the PCIT are hereby quashed.
PCIT Bhubaneswar. PCIT Bhubaneswar.
Bhubaneswar 1.
And all consequential actions prepared. He has said
all consequential actions are hereby quashed. All right.
Most greatly obliged.
All right.
Supplementary list item number 12.
Lord, the prayer I'll be making for a lordship may cause little inconvenience for your lordship, Lord. This is a matter where state argued that there is absolute no material to suggest that the petitioners were engaged. Based, your lordship, privacy was taking, you are taking a view that based on.
That was not my submission. My
one second,
submission
Mr. One second.
No, I'm just
one second, I'm making a prayer to tag it to some other CM appeal. That's the reason I'm trying to tell your lordship, my lord. So the question of that termination restatement was pending adjudication in another writ petition, which was dismissed for default. Now we have applied for restoration 296 of 2022. That's what I was trying to make a prayer to your lordship. Let both the matters be taken up together because our material with regard to our employment and continuance is available in that matter.
I see. Which is that file?
But that is CM APL 296 of 2022.
List along with CM APL 296.
296 of 2022.
Of 2022 on, is that listed?
Your lordship.
That's not listed?
No, recently filed.
Oh.
Maybe sometime next week, my lord.
I think 12th August. No, not 12th. Sorry. All right, 8th August.
8th August. Grateful.
Supplementary list item number 13.
Item 13, Milords. In this batch of matters, Milords, I have entered appearance for the respondents. May I request my learned senior Mr. Satpathy to kindly serve a copy of the appeal memo. Milords,
all right.
Identical matter, Milords, have kept the identical matter on 23rd November.
All right. Mr. S.K. Acharya enters appearance on behalf of the opposite party. Respondent. Copy of the paper book be supplied to him.
Your Lordship, Mr. Acharya's name may be deleted and my name may be recorded.
Yeah. Mr. Satpathy's name and then.
Oh, bless.
List on 22nd November.
Yes. 23rd November.
23rd November. All right.
I'm obliged.
All right.
Supplementary list item number 14. Item number 14.
Database system.
Supplementary list item number 15.
Petitioner, my lord. It's a public interest litigation where your lordship has called for a counter from the state.
Yes, I have filed it. I'm just.
I see. The reply has been handed over today in court. Adjourned if any be filed for the next day. What has happened? Actually, what do you say in the counter?
See, rehabilitation program.
No. What do you say in the counter, sir?
Yes.
This F series, what I see that it requires
Page
an affidavit.
13. Page 13 of the counter. Behind. But it is e-filed.
All right. You say adjourned to be filed for the next day. We'll have it on some other day.
No, I'm giving hard copy also right now.
We'll have it on 11th October. 11th October. Or
I will file my affidavit, my lord.
correct.
Supplementary list item number 16.
May I please your lordship.
16.
As directed by this honorable court, the petitioner has already submitted the comprehensive reply.
The copy of the comprehensive reply kindly be given to me, my lord.
Already filed in the office.
I could not get a copy. I
I have filed 2 times.
I would request my lord and friend to give me a copy, my lord.
Okay, 1 second. I will give.
Comprehensive note of submission.
Yes.
Petitioner's comprehensive note of submission be made available to Mr. B.P. Tripathi, Learned Counsel of the State.
Yes, my lord.
You have a matter on Saturday. No? One of these Saturdays, 24th September.
Obliged, lord.
24th September.
Obliged. My lord, my name is not mentioned in the cause list.
All right. Put down his name. 24th September.
Yeah.
The working Saturday.
My lord, please be include my name in the cause list.
All right. Sir.
Yes. SK Padi.
Okay.
Supplementary list item number 17.
My lord, my lord, with your lordship's permission, my lord, item number 14 was simply in a different court. May it be taken on Monday, my lord.
No. Tell us what it is. We'll do it right now.
My lord,
We'll do it right now, sir. Tell us what it is.
my lord, I pray for Monday, my lord.
So if you have the paper book, argue. What is the problem?
After lunch, my lord.
Why after lunch? If you want, we'll pass it over. We'll pass it over. You come back. All right.
Supplementary list item number 17.
May it please your lordships. I'll not take much of your lordship's time.
Right.
I'll only place some annexes. And your lordship will agree that if an order is passed beyond the period of limitation, it is void ab initio. Lordship will kindly see Annexer 8, an assessment order at page 33 was passed on 6/4/2017 for the assessment year 15-16. Now, your lordship will kindly see section 263(2).
Yes.
No order shall be passed beyond 2 years where from the date of where the order of the financial year in which the order has been passed. Now the financial year is 17-18.
Yes.
And the order supposed to have been passed by the commissioner in the revisional authority by 31st of March 2020. Now he passes an order, lordship will see, that is on
21st April.
Yes. 20 kete? 21/4 yes. 21/4 कोडी गला सेटा reply yes.
Annexure 11.
Answer 49 Annexure 11 page 49
21st April.
21st April. It is totally void ab initio.
All right. What do they say in the reply?
Reply they have not said about that. The reply has been filed and I have got the copy today. They have just relied on a board circular that is on a different context. But on the face of it, my lords, the order is void ab initio. You cannot act upon it to pass an order of assessment. Order of assessment again has been passed on 30th of August, 30th of September 2021, Annexure 19, page 79. And if the order is void ab initio, how can you give effect? That is my submission, entire submission before Lordships. Very recently, also I'm very unfortunate. I could not bring to the notice of this Honorable Court the judgment of the Supreme Court rendered by Justice Saha, where they have said that order to be made, and that is very important, which occurs in 263. Order to be made. Order has to be made by that the due by 31st of March 2020, and he passes the order beyond the period of limitation.
Yeah, but that was in the context of issued, made and issued.
Yes.
So actually, in the some other matter, we said unless it is
issued. Yes. But your Lordship will see the language language in the statute itself, because we cannot go beyond the.
No, but I don't know whether you raised this as a plea in your petition, because there's no reply to that.
Nothing were there, my lord, in the petition.
You don't seem to have raised this limitation as a ground.
Limitation, yes. Limitation, that is correct, my lords. I bow down. But on the face of it, my lords.
Because in his reply, he had no occasion to meet this ground.
Yes.
In reply to the notice, did you say that?
No, I have not said. Reply to the notice also. My lords, if...
yes, my lord, to the notice, my lord, 263 notice, well, they have submitted the reply.
No, they may not have raised it in the reply or the petition, but it's still a question of law.
Question of my lord.
Question of law, my lord.
That because that has not been pleaded in the repeat.
That's all right, sir. You still have to be ready with that.
Saurabh Jain versus ABBP, that is reported in 2021 Supreme Court, in the month of August by D.Y. Chandrachud. If para 31, 32, 33, 34, the Supreme Court has said that the jurisdictional issue can be raised at any time.
Yes.
I'll supply the judgment, my lords, of the Supreme Court.
All right. Section 263, bracket 2. You said the challenge of the present petition is to an order of... It can be only to, order of assessment. Dated 30th September 2021, passed under section 143, bracket 3, oblique 263 of the Income Tax Act 1961 for the assessment year 1516, bracket AY, you say. And the order dated 21st April 2021. Passed by the Commissioner of Income Tax under section 263 of the Act. Revisiting the assessment made for the above AY, originally made for the above AY on 27th December 2007 and setting it aside. Full stop. The background facts are that for the AY in question, pursuant to the return filed, the return filed with the SSC petitioner SSC was taken up for scrutiny, and an assessment order was passed on 27th. When was it passed?
It was passed on
21st April 2020.
No. Assessment
Original
order
assessment
6/4/2017, Annexure 8, page 33, my lords.
Yeah, was passed on 6th April 2017. Paragraph. It is the above assessment order which was sought to be revisited by the CIT by issuing a show cause notice dated 24th February 2020 under section 263 of the Act. After the petitioner filed a reply thereto on 20th February 2020, the impugned order was passed by the CIT under section 263 of the Act on 21st April 2020. Paragraph. Mr. Rai, the counsel appearing for the petitioner, refers to section 263(2), which mandates that, open quotation, no order shall be made in subsection 1 after the expiry of 2 years from the end of the financial year in which the order sought to be revised was passed, unquote. Although Mr. Mahapatra and senior standing counsel for the department urges that this plea was not raised either in the reply to the notice under section 263 of the Act or even as a ground in the present writ petition assailing the order passed thereunder. Fact remains that this goes to the root of the matter. Stop. Such a plea can be raised at any stage of the proceedings, notwithstanding that it may not have been pleaded as such at the first instance. Paragraph. The financial year in which the assessment order has been passed for the FY in question is the year 17-18. Full stop. It was therefore mandatory in terms of section 263(2) for the CIT to have single quotes made, unquote, the order within a period of 2 years from the end of the said FY 17-18. That is, it should have been passed on or before 31st March 2020. Most of admittedly, the impugned order under section 263 of the IT Act has been passed on 21st April 2020, which is beyond the period of 2 years. Most of consequently, the mandatory requirement of section 263(2) of the Act is not fulfilled, and accordingly, the said order dated 21st April 2020 is hereby quashed. Paragraph. The impugned assessment order, which is passed as a consequence of the above order, on
30th of September,
30th
and it's a 19.
Yeah, on 30th September 2021 is also hereby therefore quashed. The petition is allowed in the above terms.
Much obliged.
Right.
Much obliged.
Item 18.
18, my lord. In this case, I pray with time to file counter. In this case, I have been sought with a additional affidavit by my lord senior, showing some facts and order sheet of the assessment proceeding where it has been alleged that notice has not been served. My lord,
on 143(2),
yes,
I have given the affidavit.
On this, my lord, I have to obtain instruction and I have to file an.
All right. Mr. Mahapatra seeks some more time. Seeks and is granted 4 more weeks' time to file a reply to join up for the next date. Interim order to continue. List on 30th November, 30 November.
Too big a period, matters. Obviously, matters.
Right.
Supplementary list for hearing item number 19.
May I please?
Yes.
I am appealing through the legal aid authority.
Yes.
Good morning. I received a Bhakalaknama in this matter. I learned from the I have also.
All right.
May I please? My lord, the appellant is convicted under section 302 of the Indian Penal Code, though he has been charged for the offence under section 302 along with 25 and 27 of the Arms Act.
Right.
But subsequently he was discharged from that offences. My lord, the law and court below solely relied upon the evidence of a PW4 has convicted the appellant. But the said being a projected eyewitness, he is not the real eyewitness, my lord. Though the two eyewitnesses, PW1 and 6, though they are the real eyewitnesses, they have been they are hostile. My lord, the evidence of a PW4, the evidence of PW4, my lord, he clearly stated in his cross-examination that the affair.
Let's read it, sir. Let's read it.
My lord, I'm placing the PW4, my lord.
Yes.
I know both the accused, deceased.
Accused and deceased.
Pardon?
And there's a word called and between accused and deceased.
Mal, I know both the accused and the deceased, Manoranjan. More than 1 year back, Manoranjan died. While I was going to village, I saw Manoranjan was going in a bicycle. Raju detained him and another accused, Bobby, fired at him. Manoranjan fell down with bleeding injuries and I ran away out of fear. Accused persons fled away towards the forest. I informed this to my employer and we again returned to the spot. I gave water to the deceased who told me that Bobby fired at him and Raju came with him. On my instructions, Chita Pradhan was scribed the FIR and I signed on it. Exhibit 4 is the report and Exhibit 4.1 is my signature. Police held inquest over the dead body and prepared the inquest report. Exhibit 5 is the inquest report and Exhibit 5.1 is my signature. Cross-examination partner. Deceased is my brother-in-law and he was detained in jail for 5 to 6 months. As he created trouble, we are not applied for bail immediately. Deceased kept an unlicensed gun which was seized by police. I do not know if he had selling gun. Manoranjan was dead on the highway. It was a busy road. My village and the village of the deceased were on different direction. The spot was visible to the hotel of Ratan, where I stayed at the previous night. The murder took place after the turning. I was going to the house of Manoranjan to inquire about the cutting of the paddy. I was at the turning when I heard the sound of gun firing. Tunu and Narendra, these are the two eyewitnesses. Tunu and Narendra Behra were at the turning, so many persons gathered there. That's after burning the dead body, being called by the IO, I went to the PS. The IO told to write that Raju caught the deceased and Bobby fired. As per instruction of the IO, the FIR was scribed and I signed on it. Chittaranjan copied out from the paper which was written by the IO. I signed on it. The report scribed by me was torn by the IO. It is not a fact that it was not going to the house of deceased and I had not seen the occurrence and that as per the instruction of the police, I am deposing falsely. The spot is at a distance of 30 to 40 meters from the hotel. I had not scribed in my FIR or told to the IO that out of fear, I went away from the spot. It is not a fact that I am deposing falsely. Well, from this para, cross-examination part, second para, it is clearly stated that as per the direction of the IO, the FIR was written by this scriber. And his evidence is not trustworthy because it is not, he variates in his own statements. And my lord, only relying on the evidence of PW4, the learned court below has convicted, though he was not charged under section 27 of the Arms Act, my lord. And the learned court below, my lord, basing on only and the internal page page 14, the prosecution relies on the direct evidence of PW4, right declaration and recovery of a gun while in police custody. Even the leading to discovery, the witnesses, those who are present during that time, they have not supported the seizure, my lord. And my lord, the evidence of a doctor, man, PW10, man. My lord, the doctor's evidence, the report is secondary one. My lord, I am placing the cross-examination part of the doctor, my lord, PW10. I have not noted whether the gun was single or double barrel gun. I have not noted the make of the gun. The wounds were not examined before PM examination by X-ray. I have not noted the entrance and exit of the wounds. I have handed over the meat with bullet to the IO. I have not opined about the distance from which the gun was fired. Not, sorry, it is not minor, nor I can state so. I have not noted if any cloth was found in the wound. I have not noted the direction of wounds. I cannot say if the bullet recovered or fired from the gun, which I examined.
So he's a doctor. Why are you asking all these questions to this doctor? He's not a ballistic expert. You're treating the doctor as a ballistic expert. You meaning whoever your counterpart.
There is no ballistic report, my lord. The ballistic expert has not been examined, my lord.
What am I asking you? What are you saying?
Pardon?
Because there is no ballistic expert, your counterpart seems to have treated the doctor as a ballistic expert. All these questions which he should be asking a ballistic expert, he's asking the doctor. How will the doctor know angle of firing and what range? How is a doctor supposed to know all this? Anyway.
But the paper, the report the doctor has written initially in the first paper, that are not also seized by the IO, and hence it is a secondary report, my lord. The report where the doctor first in PM, while conducting PM, made the report, and thereafter it is written again. Hence it is a secondary report, my lord. And the doctor also has not reflected in the report that whether the injuries sustained are post-mortem or antemortem in nature, my lord. And my lord, the evidence of PW, he is interested witnesses and brother-in-law of the deceased, and his evidence suffers from infirmities, my lord. The PW 1 and 6, those witnesses are real eyewitnesses. They have stated that the PW 4 was not there. He arrived at the spot after 15 to 20 minutes at the spot, my lord. He has not seen the occurrence, my lord. And he stated that while he was in the turning, he heard a sound of firing, and thereafter he went to the spot and offered water to the deceased, my lord. And the PW 6 categorically stated that, my lord.
Did the deceased say something?
Pardon, my lord, P 6.
Whether the victim said something.
This is said that the person accused, my lord, the co-accused who was accused, he was there, and the present appellant fired at him.
What is the nature of that statement?
The oral, my lord, oral evidence, but P 6 stated
Under what
that
provision?
oral dying declaration.
Under what provision of the act of law? Under what provision of law, sir? Are you aware?
Pardon.
Under what provision of law? Oral dying declaration, under what provision of law is it admissible in evidence?
Oral evidence is not
Oral dying declaration.
Oral dying is not acceptable, my lord.
What?
If it was not,
Have you studied the law, or you're simply saying? Have you actually studied the provision, or you're simply saying like this?
Pardon, my lord, I have not gone through that oral.
First, you should say yes or no. I asked
No,
you,
no.
have you studied the law? You should say no.
No, ma'am.
Please give him the Evidence Act. You don't have the Evidence Act? You don't have the IPC?
My lord.
Please open the Evidence Act, sir. Please see section 32.
Section 31.
Are you aware of the case law on this? Are you aware of the case law on this?
My lord, I just
No.
day before yesterday I got the file, my lord.
Sir, we studied this in our law college. All right. Anything else, sir?
My sole submission is that the PW4, the evidence of PW4 suffers from many infirmities, and the FIR lodged by him is as per the direction of the IO.
All right.
And he was not present at the spot. He has not seen the occurrence. And he simply projected as IO, though he was not the real eyewitness to the.
Plus, only I just want to bring to Lordship's kind notice. A question has been put to the IO at page 51, and he has page 51 plus. It is not a fact that I asked Rudanand, the informant, to scribe the report, and he copied out the report from the report scribed by me. So he has not dictated the FIR, because if suggestion has gone from the side of the defense, what he has denied. And here, as far as PW4 is concerned, because here he has seen the occurrence, and also he is the accused before dying has said that I gave water to, I'm reading the exact sentence, I gave water to the deceased who told me that Bobby fired at him. So this is an oral dying declaration. And you'll also find in the entire cross-examination, this particular statement, Bobby fired at him, plus you'll also not find any cross-examination over that. So that remained consistent. Even no confrontation has been made to the IO. And nature of injuries, you'll also find 10 gunshot injuries. PW10, that is at page 44. All are punctured wounds. 10 punctured wounds. And internal injury was by fracture, then pleura torn, peritorium was also perforated.
So and fired at more than one.
Yes, so 10 wounds. And page 46 I'm reading was the cause of death of deceased were due to shock and external hemorrhage due to injury to great vessels of left side of neck. Vital organs like left lung, duodenum and transverse column, which was caused by firearm. It's so clear, doctor. And then also weapon of offense, the gun has shown to him, and he has opined that name of the gun, gun 118.5 cm,
a trigger and firing pin was also found over the gun. The injury found over the deceased Manmohan can be possible by this seized weapon. So this is also the opinion. And so far the law says dying declaration laws, basing upon the dying declaration only, even the conviction can be possible. There are so many judgments of the Honorable Appellate Court. I can provide all those judgments. And the witness P 4 cannot be stated to be interested because he is related. Of course, my learned friend has not said so because he happens to be the brother-in-law of the deceased. So because he is related, he cannot be said to be interested because related is different from interested, as has been said by the Honorable Appellate Court in very many decisions. There also I can provide a judgment to the Lordship.
Or we have.
This is a related and interested witness also. There was at para 7 of the judgment, State of Rajasthan versus Srimati Kalki and another. Highly interested witness because she is the wife of the deceased and there are discrepancies in her evidence. With respect, in our opinion, both the grounds are invalid. For in the circumstances of the case, she was the only and most natural witness. She was the only person present in the hut with the deceased at the time of occurrence and the only person who saw the occurrence. True it is, she is the wife of the deceased, but she cannot be called an interested witness. She is related to the deceased. Related is not equivalent to the interested. A witness may be called interested only when he or she derives some benefit from the result of a litigation, in a decree in a civil case, or in seeing an accused person punished. A witness who is natural one and is the only possible eyewitness in the circumstances of a case cannot be said to be interested. And this judgment also has been referred in the second judgment, State of UP versus Kishanpal and others. That also I have given to Lordship.
That's it. Para 19. We've seen that. All right. Anything else, sir?
My Lord, only I want to submit that when the appellant has been discharged from the offence under 25 and 27 of the Arms Act, the learned court below should arrive at the finding that he should not be the author of the crime.
He has been acquitted of 25 and 27 of Arms Act. But that cannot be said that he is not the author of the crime.
Orders reserved.
Highly note of submission by Monday.
My Lord.
Highly note of submission by Monday, my Lord.
All right. Whom are you for, sir?
Well, I am appearing this matter, but your Lordship direction to argue the matter so that.
All right. All right. Note of submissions be submitted within 3 days. All right.
Supplementary list item number 20.
I am there for appellants 2 to 4.
All right, sir.
I am for the appellant number 1, my lord.
All right.
In this case, Lordships, that in the name of Dara Singh, I have been convicted, Lordships, and there is a dispute between the two religions, Congress, Christianism and Hinduism, my lord. The petitioners are the Hindu, and the opposite parties are the Christians, Lordships. And the dispute arose on the basis upon that, my lord. Being I am the leadership of RSS, I have been falsely implicated into this case. In Dara Singh, Lordships. Lordship, kindly see. Now I am in custody about 22 years, Lordship, in jail custody, Lordships. So far as the allegation is concerned, Lordships, the accused persons being armed with the bow, arrow, lathi, had gone to the church, broke upon the lantern, and assaulted and killed the father, and thereafter they escaped from the spot, my lord. Lordship, kindly see the para 2 judgment, para 2, Lordship, my lord. The investigation was set in motion after lodging a written report by the Kate Singh Khuntia PW3 at Surat police station at about 2 a.m. in the night, when some persons, Christian faiths, dancing informant Jambani church. He along with deceased Arul Das was sleeping inside the church. 4 to 5 persons armed with lathis entered into the room in which they were sleeping and shouted that their father was sleeping. The deceased father Arul Das woke up and went outside. While he PW3 was coming out of the mosquito, somebody assaulted on the backside of his head by lathi. He became senseless. Sometimes after he regained his sense, their head Arul Das was shouting loudly, "Ma, ma!" Out of fear, he went into the nearby jungle. Thereafter, arrived at Sarad police station, 5:30, so and so, my lord. So far, this concern, my lord, PW3 is not eyewitness. Lordship kindly see. Para page 107, lordships is categorically stated in cross-examination, my lord. I could not identify the assailants due to darkness inside the church. Due to assault on me, I fell due unconscious inside the church, my lord. The relevant para, my lord. In the chief 107, lordships.
Yes.
Thereafter, lordship, out of the prosecution, lordships, 21 witnesses faced trial, my lord. Out of 21, my lord, 17 accused persons acquitted, whereas 4 persons we have been facing trial, lordships, and convicted thereunder, my lord. The lordship kindly see, as per the prosecution is examined, my lord. "23 witnesses, lordship. Out of 23 witnesses, lordship, kindly see para 5, para 4, my lord. PW3, the informant, it is not believable and do not know, my lord. Here, my lord, only challenge is identification is under challenge, lordships. And PW3 informant, PW1, PW2, PW4 to 8, PW10 and 13 are the eyewitness, my lord, for the prosecution. Lordship, kindly see. PW5, my lord, PW12, PW9, my lord. Can I see PW9, lordships, judgment. PW1 has admitted that due to darkness, he could not identify the 14 to or 15 persons, my lord, who had assaulted him and others. PW3 had not identified any of the assailants, not due to darkness inside the church, but he had heard some of the assailants shouting loudly, "Darabhai," the father of the was sleeping there. PW7 and 8 generally implicated the accused person dog. PW7 during cross-examination denied the suggestion that he had stated before the police that he could not identify any of the accused person, my lord. But the IO PW22 confirmed it. PW8 simply stated that he know the accused person in the dock and the accused person missing who is in my village without attributing any overtact or specific omission on the part of the particular accused. Therefore, the evidence of the above witness is not helpful in identification of the accused person, my lord. Here, my lord, 1378 is not helpful, my lord. Thereafter, lordship, kindly see PW para 13, my lord. Para 13, my lord. Sorry, para 12, lordships. Here, my lord, para 12. PW4 identified the accused Silipurti, Dumbi Bodra, Jodunath Moto, Dambudra Moto, Dundubodra, not identified the Darasing, my lord. He did not know their names, but identified them individually in court as among the persons who had assaulted the deceased Arul those in front of the house near the Dr. Banana plant, my lord. So kindly see, my lord, para 3, my lord. Here also, PW5 knew the accused person, Jodunath Moto, Darasing in their name, as they had come to 3 p.m. in search of Buffalo and the house of accused Bisingo. He implicated accused Darasing specifically in breaking the lantern, my lord. PW5 is only implicated him as breaking the lantern, lordship. He has not stated if the accused Jagannatha Mahato was among the accused person who had come to church in the night. He has generally said that he knew the accused person, they had gone to the church committing offense, my lord. The lordship kindly see the PW23, lordships. The cross-examination of the IO, my lord. On 12 I had examined PW3, PW had stated before me that Arul Das slept inside this, but he had not stated before me that he is ill, had not stated before me that what father woke up and asked him what happened. This person told loudly, he had not stated before me that he had heard the sound of the assault on the father, that when he was playing into the forest, those persons shouting, I have examined PW5, my lord. In Oriya language on 19, he had not seen. She had not studied before me while they were taking rest at about 3 p.m. 4 persons, Jagannath Mahanto, dancing along with other persons, came to the church in search of buffalo and advised them to search near the house of the Veera Singh. The accused Dara Singh broke out the lantern burning at the time of dance, my lord. Thereafter, para 8, my lord. I had examined PW6 on 14th October 1999, who stated before me in Odia language. He had not stated before me that the accused persons came about 2 a.m. when the dance was going on, and the accused Dara Singh broke upon the burning lantern at the place and shouted, Mara Swatu. He had stated before me that he could not identify the assailants, my lord. My lord, Lordship, kindly see para 10 also. Para 10, my lord. PW10 identified the accused persons of Subhadra Putri, not the Dara Singh, my lord. However, he has implicated all the other accused persons coming in the body to the place of dancing armed weapon and chasing deceased Arudas from the church. PW10 has not attributed anything against the accused persons whom identified to be the co-villager, and if they, along with other co-accused persons, had come to the church when the dance was going on, his identification of accused person is of no consequence. In similar manner, PW13 blindly stated that he knew the accused person standing in the dock, but during cross-examination, admitted that he had seen the accused person for the first time on the date of occurrence while the dance was going on the church premises, and he had not seen them prior to the date. So the evidence of identification is little consequential, lordships. So look, kindly see thereafter, my lord, kindly see the para 12, lordships.
You already read 12, sir.
And none of the witnesses have stated that he was at the time of occurrence. None have seen that at the time of occurrence he was assaulting, my lord. And none have stated, my lord, who is holding the, my lord, any weapon of offences, lordships. Lordship, thereafter, none of the witnesses has directed witness to see the occurrence, lordships. And lordship, kindly, other one, my lord, one last thing, my lord, lordship, kindly see the post-mortem report, lordships. PW, my lord, 15, lordship, kindly see. The doctor PW 15 was conducted the post-mortem examination, lordship, kindly see. Here, we have mentioned, my lord, last para 4, we have mentioned that the description of the arrow recovered from left side chest in the post-mortem report, my lord. The recovered arrow was headed about to the constable so-and-so. The cause of death was hemorrhage due to abdominal chest cavity, shock. The injuries were antimortem nature. The injury number 1-3 were caused by sharp cutting weapon, preferably an arrow. Injury number 1 is specifically caused by the arrow recovered from the body of the deceased, my lord. My lord, here only 2 MO is there, one arrow and other one is, my lord, lathi, my lord. So my respectful submission, my lord, here. Not a single witness stated how the deceased sustained such an injury, and none of the witnesses stated that unknown is a FIR, my lord, not have seen the occurrence. Not a single person stated that the present petitioner was holding such arrow or assaulted any weapon of offences, my lord. And no leading to discovery, no recovery, nothing, my lord.
How do you suddenly find it?
Here, thereafter, my lord, so FIR is specifically stated 4 to 5 persons, my lord, specifically, my lord. But convicted is faced a trial, my lord, 17 persons faced a trial, 21% faced trial. Out of them, they were acquitted, 4 persons were convicted, lordships. My submission, lordship, none of the witnesses have stated at time of occurrence, and none of the witnesses stated that he is assaulted and he was holding such a type of offense, my lord. And the doctor stated, my lord, only one arrow for which he was caused death, my lord. And 149 CRPC, lordships. And out of 21, 17 persons were acquitted, and their act as assembly to achieve the object. When common object upon online assembly is not proved, the accused persons cannot be convicted under the help of the section Lordship 149 CRPC, my lord. If the 17 persons were acquitted on the ground that they are not a member of unlawful assembly, it cannot be forthwith how to section 4 persons were convicted, could be convicted by taking the recourse of section 149 APC lordships. Thereafter, my lord, no recovery made from the either person or the profession of the appellant to connect the crime. The conviction should set aside and liable to set aside lordships. Appellants being unknown in the affair and unknown the witnesses and having been convicted on the basis of identification made in doubt, my lord, such identification ought to have been discarded in view of the fact to no TI paradise conducted lordships. So taking the submission, my lord, being the petitioner is custody about 22 years in jail custody, let them maybe acquit from the charges and my lord.
All right. Yes, Mr. Panda.
My learned friend has placed the materials before your lordship.
Yes.
As your lordship will see the charges, there is absolutely no specific charge either on section 323 simpliciter, 302 simpliciter, 436, 452, or even read with 34 millards. It is also not the prosecution case that beyond the 21 persons who faced trial, others were involved, millards.
Yes.
However, the trial judge, millards, has come to the conclusion that these appellants are guilty of having committed offences. Read with section 149 has convicted them also under section 147 and 148, while acquitting them of the charges of conspiracy and of harboring of the appellant. Number 1, millards. My submission is that in view of the specific evidence on record, that only 4 persons were found guilty, millards, he could not have convicted them with the aid of 149, nor a conviction on section 147 or 148 would lie. That apart, millards, your lordship will see the FIR. As per the FIR, only 4 to 5 persons are alleged to have committed the offence, millards. The informant has not identified anybody, millards. The identification is solely identification made in court of the accused persons, appellants who have been convicted. That is apparent from the judgment of the trial court, millards, at paragraphs 11 and 12, where he discusses about the present appellants. Page 23 of the paper book, your lordship may see.
Yes.
PW2, while adducing evidence, identified accused persons Rajkishore, that is appellant number 2, Chemma number 4, Dara number 1, and Jadunath number 3, among the 15 to 16 other accused persons who had come to church on the night of the occurrence. He did not know their names, but identified them because earlier on the day at about 2 p.m. after the prayer, they had come near the church in search of buffaloes and the house of accused Bir Singh Ho. Now, Bir Singh has been acquitted, millards. On their request, he had pointed out the house of accused Bir Singh, so he could identify them among the 15 to 16 persons who had come to the church in the night and perpetrated the crime. Again, at para 12, he says, PW4 identified accused Silai, who have been acquitted, Dambi Bandra, who has been acquitted, Jadunath, who is the appellant here, Dambaru has been acquitted, Gundu Bandra alias Ho, and Pardhan Purti, who have been acquitted. He did not know their names, but identified them individually in court as among persons who had assaulted deceased Arul Das in front of his house near a cluster of banana plants. Next paragraph is para 13. PW5 knew accused Jadunath and Dara Singh in their names as they had come at about 3 p.m. in search of buffaloes and the house of accused Bir Singh. He implicated accused Dara specifically in breaking the lantern. He has not stated if accused Jadunath was among the accused persons who had come to the church in the night. This is important. He has generally stated that he knew the accused and they had gone to the church to commit the offense. Then your Lordship may see para 15, the discussion. Evidence of PWs 2, 4 and 5 remain to be scrutinized whether the evidence would be relied upon to fasten any criminal liability on any of the accused. Learned Defense Counsel submitted that accused were not known to the witnesses prior to occurrence, and in absence of TI parade, their evidence of identification is worthless, and he relied upon Muhammad Abdul Hafiz versus State of AP 83 Criminal Law Journal 689 Supreme Court, and Kanan and others versus State of Kerala 79 Supreme Court 1127. In Hafiz case Supra, in a case of robbery, the description of the accused was not mentioned in the FIR after the incident, and accused was identified for the first time in court during trial. In Karnan's case Supra, the reasoning of the lower court that evidence of a witness regarding identification cannot be discarded only because TI parade was not held. It was held in the facts and circumstances of that case that evidence of identification was not reliable. Coupled with the absence of the TI parade, there was no evidence regarding identification of accused. In Pramo Mandal versus State of Bihar, 2004-29 OCR Supreme Court 501, issue as whether in absence of TI parade in respect of an accused whom witness did not know prior to the occurrence, evidence of such witness is worthless. It has been held that this rule of prudence, however, is subject to exceptions when, for example, court is impressed by particular witness on whose testimony it can safely rely without such corroboration. Substantive evidence is the evidence of identification, but not the TI parade conducted during investigation. It's a rule of prudence that to judge veracity of a witness regarding identification of an unknown person, TI parade is necessary, but it is not the rule of law that no TI parade, no conviction. TI parade being not the substantive evidence, its value lies in corroborating a witness regarding identification. There is no legal requirement that corroboration is always required to accept evidence of witness. In Muhammad Salem versus State, 1991, Volume 3, Crimes 459, relying upon the decision of the Honorable Supreme Court in Jadunath versus State of UP, 71 Supreme Court, it is held that absence of TI parade in all cases is not fatal. If the accused is well known by sight, it would be waste of time to put him up for identification. Absence of TI parade simpliciter cannot be a ground to show evidence of identification if otherwise reliable and inspires confidence. Now it's for your lordships to see whether this evidence which the trial judge says is reliable and inspires confidence. They are not known persons. The descriptive features have not been stated by them before the police. Even the fact which some of these witnesses say that these appellants had come in search of the buffaloes and also the house of the co-accused Bir Singh, that has not been put before the stated before the IO, as my learned friend pointed out from the cross-examination of PW23. So whether this solitary identification in court by witnesses who have not given descriptive features, by witnesses who do not know the accused person's millards, and by witnesses who were not put to a TI parade to identify the accused after the arrest, whether the sole identification in court is sufficient, that is to be decided by your lords. Para 16, what he says is like this, page 26. PW2 identified accused Rajkishore Mohanto, Chemma Ho, Dara Singh and Jadunath as he had seen them for a pretty long time during daytime at 3 p.m. when they had come in search of buffaloes and the house of accused Bir Singh, and he pointed out them that house. He found them among the persons who had come armed to the church in the night when their features were fresh in his mind. Then the court relies upon Sivaraj Bapuraj Yadav versus State of Karnataka, 2003, 2 Crimes 161 Supreme Court, where the incident took place at 11 p.m. 2 days prior to the new moon day. PWs 1, 4, 5, and 6 were eyewitnesses. Appellants contended that it was impossible for them to identify persons and witness the incident. It has been held that parties are used to live in the midst of nature, accustomed to live without light. Parties would have been identified easily not only from the voices, but from the fact that they were known persons and close relatives living in neighboring huts. Now, this is not so in our case. The court also says in the next sentence, though the facts and circumstances of the other's case regarding identification is different, fact remains that the persons used to live in midst of nature and accustomed to live without light can identify anybody in insufficient light and even at times in darkness, which is not possible on the part of persons accustomed to live in light. 5 was in the church at about 3 p.m., few hours before the incident, when the 4 persons, including Jadunath and Dara, came in search of buffaloes and the house of accused Bir Singh, and he showed them the house of Bir Singh, and 5 lives in a remote Adivasi village, and power of cognition is sharper than persons living in urban areas. Witnesses like PWs 2 and 5 do not see outsiders regularly. When they have occasion to see any outsider at any point of time, they used to remember their features for a long time when they get a chance to see them again. Now, para 17 Milords, there is some discussion of identification of by PW4. PW4 was sleeping in his house in the night and woke up hearing shouts outside at about 2 a.m. and saw the deceased was being assaulted near his house by some persons armed with lathis, bows and arrows. He identified accused Sillai Purti, Dumbi Bandara, Jadu Mahanta, Damburu Mahanta, Dundu Bandara alias Ho and Pardhan Purti by pointing them during trial and stated that those accused were among the 12 to 13 persons assaulting Father Arul Das. My submission, my lord, is this. If this identification is acceptable in respect of the appellant Jadunath, why did the trial court acquit the other co-accused milords who have been identified in the similar fashion?
Yes.
He has not stated what was the occasion prior to the occurrence that he could come across accused. He has identified. As he did not know their names, it would be very easy to point out persons whom he knew to be the accused when they are in dock. Similar reasoning, milords, applies to Jadunath. Evidence of 4 regarding identification cannot be accepted beyond reasonable doubt, specifically when it has not stated if there was any light source to identify them. Now, milords, if this is the opinion of the court, milords, with regard to the identification of co-accused, how can my identification be sustained? And one other important thing, milords, I would like to say, that yes, these factors on which reliance have been placed, they have not been put in the 313 statements. Would your lordship look at the 313 statements, page 79 of the paper book?
Yes.
First question to Jadunath is, PW4 deposed that you along with other accused entered Jambani church in the night, assaulted Arun Das in front of the house of PW4, armed with weapons like lathis, bows, arrows. And in the morning, he saw Arun was lying dead inside his house. The next question is PWs 2, 5, 6, 7, 8, 10, and 13. Deposed that you along with other accused came near Jambani church sometime after midnight, armed with weapons like lathi, bow, arrow, assaulted persons dancing near the church, broke the lantern burning there. What do you say? Third question. They also stated that you trespassed into the church, assaulted Arul, as a result of which he died and burnt the church. That's nothing specific. This buffalo part, milords, is also not put to us in the 313 statement, that we had come in search of buffaloes and the house of Bir Singh. Other questions are irrelevant.
All right.
And in a connected matter, I had placed before your lordship that a conviction under substantive sections read with 149 will not lie if there is acquittal and the number comes to less than 5 millers.
Right.
So I don't think I should repeat those. I'll only give those citations, my lords.
All right. All right.
And my submission is that it is not the prosecution case, that beyond these people who faced trial, there were any others involved.
Okay. Okay.
May I resource? So I am permitted to place the deposition of Schedule 5 at page 114.
Yes.
Yes, I know the accused person standing in the dock. I know the deceased father, Aurul Das, who died about 5 years back. On that day, Hero festival was being celebrated in village Jambavani. Father Aurul Das, along with Darshan Biura and Katta Singh Khuntia, and come to Jambavani church on that day. At about 9 a.m., prayer in that church started. The prayer in the church continued till 2 p.m. of that day. After the prayer, the people gathered there, went back to their houses. But myself, Darshan Biura, Katta Singh Khuntia, Durga Gadsara, and Father Aurul Das remained inside that church. We took food in the church at about 3 p.m. While we were talking there, 4 persons came in search of buffaloes. Accused Jadunath and Dara Singh, both are nameless here, were among those four persons. I do not know the names of other 2 persons who were with them. I told them to search for the buffaloes near the house of accused Bir Singh Ho. Then they asked me to show the way leading to the house of the said accused. On being asked by them, I had shown them the way. Thereafter, those persons went towards the house of accused Bir Singh. At about 4 p.m., I left the church and went back to my house. At about 7 p.m., I came to the church again from my house. At about 9 p.m., people started dancing in the church premises. At about 11 p.m., rain started, and hence the dance stopped and people came inside the church to take rest. After 2 or 3 minutes, when rain stopped, we again started dancing in the church premises. At about 2 p.m., the accused, it may be 2 a.m. The accused persons came there. Accused Dara Singh, here specifically named, broke the lantern which was burning at the place of the dancing. Thereafter, the accused persons started assaulting, but I can't say to whom they assaulted. The accused persons also entered inside the church. Father Aurul Das and Katta Singh Khuntia were inside the church at that time. They assaulted Father Aurul Das in the church. Then Father shouted, saying, "Malo, malo," and went towards the house of Durga Gadsara. Thereafter, I went to the forest from the church. While I was in the forest, I saw the church burning. In the morning, I returned from the forest and saw Father Aurul Das lying dead inside the house of Durga Gadsara. Also, I found the church completely burned. Plus, your lordship will find in the cross-examination. I may permitted to read the whole.
No, para 3 lordship can see.
Just a minute. Just a minute. Let me
Cross
finish.
the para 3 lordship.
Will give a reply.
Yes.
I was examined by the police twice in this case. I gave my statement before the police in whole language, and the police scribed the same. I am a Christian, but I cannot say whether I am a Baptist or Catholic Christian. About 15 families reside in village Jambani. Out of 7 families are Christian. After the occurrence, police remained in village Jambani, making a camp there. The house of Durga Gadsara is about 15 cubits away from the church. I can't say in which direction of the church the house of Durga Gadsara situates. Village road runs in front of the church. Dancing was going on the other side of the road near the church by the time of occurrence. I was examined by the police in Jambani school on the following day of the occurrence. One day thereafter, police again examined me in that school. I was not examined by the police thereafter. About 25 to 30%, including me, had taken part in the dance. Bir Singh Ho, PW1, was dancing near me at the time of occurrence. I had not taken handia or liquor on that day. After the lantern which was burning at the place of dancing was broken, I, along with others, left that place and went away. I went to the forest, which is at a distance of about 200 cubits from the spot. It is not a fact that I had not stated before the police that after prayer, the people gathered there, went back to their houses. But myself, Darshan Birua, Katta Singh Khuntia, Durga Gadsara, and Father Aurul Das remained inside the church, and we took food in the church. And that while we are talking, At about 3 p.m., 4 persons came in search of buffaloes, and that accused Jadunath Mahanta and Dara Singh were among those 4 persons. And that I don't know the names of other 2 persons who were with them, and that I told them to search for the buffaloes near the house of accused Bir Singh. And that at about 2 p.m., the accused persons entered inside the church and assaulted Father Aruldas in the church, and that Father Aruldas shouting, saying, Malo, Malo, Mother, Mother, he was calling, saying. And that I went to the forest from the church, and while I was in the forest, I saw the church burning. In plus, paragraph 5 is very important. In the early morning before sunrise, I returned to the village from the forest. I can't say whether police came to the village on that day or not. I had not met PW 1, 2, 3, and 4 on that day, but I had seen them on the next day. It is not a fact that while the dance was going on, Father Aruldas was having illicit sexual intercourse with a girl of Ho community to whom he had converted to Christianity few months back, and that Kate Singh Kuntia was guarding them in the church at that time, and that on seeing the said occurrence, the people of my community assaulted Father Aruldas and Kate Singh Kuntia. This is the suggestion loss. The loss, we can appreciate the nature of suggestion. It is not a fact that there was no such occurrence and the accused persons had not come to the church premises and had not taken part in the alleged occurrence, and that I am deposing lie. It is not a fact that we are trying to convert the people of locality to Christianity, and those who are not willing to accept that religion, we harass them by filing false cases. So from this evidence of PW5, it is very much clear that Dara Singh and that Jadunath were known to that witness, and he has seen them earlier on that day also, and also he has seen them in the night, because Dara Singh came and broke the lantern. Thereafter, out of fear, must be out of fear, these persons fled to the nearby forest. And when they returned, they found the deceased lying inside the house of Durga Gadsara.
May I submit, my lord? Lordship, kindly only see to Video 23.
He has not finished, sir. Let him finish.
One thing, my lord.
Let him finish, sir. Then we'll hear you.
So, to attract section 149 of the Indian Penal Code, it is only required that the person should be a part of the unlawful assembly. Once the part of unlawful assembly is proved, that person, whether he has committed the crime, whether he has assaulted or not, he has to be convicted. Because suppose this person here, the deceased has died, and assault has been made by Dara Singh. Let us assume Dara Singh has assaulted, but Dara Singh, along with some others, form part of that unlawful assembly, then other persons also will.
No, the numbers.
It's a vicarious liability.
Mr. Panda is mentioning how many? 1 + 4, 1 + 3. What is it?
Because
that fact, Mr. Patkia is conveniently ignoring me.
That's why I'm drawing his attention to that. Yes.
That has been also decided in many cases. In Bhagwan Singh for state of MP, that is 2002, 4 SCC, page 85. I am reading a paragraph of that sentence. Common object, as contemplated by section 149 of the Penal Code, doesn't require prior consent or meeting of minds before the attack. Generally, no direct evidence is available regarding the existence of common object, which in each case has to be ascertained from the attending facts and circumstances. When a concerted attack is made on the victim by a large number of persons armed with deadly weapons, it is often difficult to determine the actual part played by each of offender, and easy to hold that such persons who attacked the victim had the common object for an offense which was known to be likely to be committed in prosecution of such an object. It is true that a mere innocent person in an assembly of persons or being a bystander doesn't make such person a member of an unlawful assembly, but where the person forming the assembly are shown to be having identical interest in pursuance of which some of them come armed, others, though not armed, would under normal circumstances be deemed to be members of unlawful assembly. Plus, in this case, some persons have been acquitted.
Sorry?
Some persons have been acquitted. As my learned senior has
that is not his submission, sir. You're not following the submission then.
No.
How many people have got convicted?
How many people participated?
Sir, again, I'll just repeat slowly so that you listen carefully, sir.
I beg apologies.
How many people are you listening, sir?
Yes, sir. I'm sorry, sir.
How many people have got convicted?
17%.
17.
Sorry. 4 persons committed lawsuits.
Let him answer, sir.
Plus one Rajkishore Mant, Chemma Ho, Dara Singh, and Jadunath Mant. 4
persons.
4%.
What is the arithmetic is for 149? How many persons should be there?
5. Well, that must be 5. More than that. 5 or more plus.
What is the charge?
Charge plus
page 50.
Yes. 120B, 323, 149, 147, 148, 302, 149, and 430.
No. Are these people charged with simpliciter offenses or only with 149?
Your Lordship may see from page 49 onwards.
No, I know
the charge.
I've seen it. Let him answer, sir.
No, not this charge not 302 simpliciter, but 302 ready with 149 and 120 with 149, 323 with 149.
What happens therefore? That is the simple argument. Mr. Panda made the argument simple, but it's actually a complex argument. What he's trying to tell you is there are only 4 people convicted. How do you sustain a conviction under 149?
Of course, yes. It can be sustained plus.
What is an unlawful assembly, sir? For an unlawful assembly, how many people do you need?
No, this is an unlawful assembly.
1 minute, sir. If you do not convict people so that there can be an unlawful assembly, how do you sustain it as an unlawful assembly? All the others are acquitted, correct?
Yes, I followed. I followed you.
Now, finally.
Followed. Yes,
the whole prosecution case now is as if only 4 people came there.
Yes.
Only 4 people participated. Only 4 people committed the crime.
Well.
In fact, that is what is there in the FIR also.
Plus, may I humbly pray, plus, for some time, plus, let me examine it. Let me examine it. I don't, because it's a very sensible issue. Let me
Mr. Mudali is also doing some homework. I think both of you should get together. You know, in our student days,
almost
we used to do combined studies.
Plus,
I don't know whether you people
I have
did.
got it, but let me
used to do
sure
combined
on that
studies.
point of law.
Mr. Panda, when are you free? You said 14th.
I'll be free, my lord. 11th, your lordship has
11th.
Problems. Let it be the week after the 11th.
That will take it to 25th.
Yes, my lord.
All right. At the request of Mr. Katke, list on 25th. You say the submissions of counsel for the appellants have been heard. Mr. Katkia, while in the course of his submissions, sought some more time to examine the matter and address arguments at his request list on 20. All right.
Supplementary list item number 21. Item 21.
Not say high.
21.
Pushparani Morana. Again present, not absent. Again absent.
No, yes, boss. No, is absent.
Legal counsel. Inform them immediately. This is repeatedly happening. No?
Last time she was present.
No, she was not present on 12th May.
But on 28th June, probably she was present. 28th June.
No, her presence is shown on 28th June.
Yes.
But again, now today she is absent. So one appellant is still appellant number 2. This is a direct evidence case.
Yes, boss. Yes, boss.
Call for. Her name is not shown in the cause list.
Yes.
Shown.
Name is shown on the cause.
So ask caller. Tell Mr. Tommy.
When I was PW 8, then last
This is
inquiry is
repeatedly
covered.
happening. Counselor just not present when the matter is called out. We'll pass it over.
Supplementary list item number 22.
So item 22, I am also requesting for an adjournment. This is because my client instructs me that he wants to engage a senior.
So, but this is pending for quite some time, sir.
I know that, my lords. He is ill. He says that he is ill and he is not in a position to come and engage a senior. And he has asked me to ask for an adjournment. I am told that he has talked with Mr. Mahapatra, but because of his illness, he has not been able to brief Mr. Mahapatra. Can it be on the 25th?
All right. At the request of Mr. Panda. List on 25th. All right.
Supplementary list item number 23.
May I please, Your Lordship?
Yes, please.
While the appellant has been convicted under section 302 and sentenced to imprisonment for life and 1 year under section 309 IPC, and the entire case rests on circumstantial evidence. In the prosecution case, Your Lordship will find page 2 of the judgment. On suspecting the fidelity of his wife, the appellant committed murder. Thereafter, he tried to hang himself. On that allegation, prosecution examined as many as 15 witnesses. Nobody has seen the occurrence. Only the PW8, the mother of the appellant, and PW2 and 3, the cousin of the appellant, they were called by the mother of the appellant, and they saw that he was hanging himself from a neem tree. Thereafter, they rescued him. On these allegations, the evidence were taken, and the circumstances the trial court has held why he did not explain his wife was murdered, first, and second thing is why he committed suicide. On these aspects, the law and trial court convicted, though in the circumstantial case, the motive is a vital part. Motive has not been proved. That is there in the judgment itself. The Lordship will find page 17, para 12. It is true that no motive has been shown by the prosecution as to why the accused could commit the murder of his wife. Witnesses are close relatives of the accused, and that is why the real motive of the accused was suspecting the fidelity of his wife Hema would not be brought to record, but the evidence on record conclusively proved that Hema, wife of the accused, was murdered by her husband, Shiva Dansena, at their paddy field, and the accused, being apprehensive of consequences of his act, attempted to commit suicide by hanging from a nearby neem tree. The non-marshalling of evidence on motive of the accused in circumstance does not affect the prosecution case.
Yes.
So since my submission is...
So the motive is proved, sir. Witnesses are
motive has not been proved.
relatives.
Motive has not been proved. No motive has been shown by the prosecution as to why the accused could commit murder of his wife. And the case based on the appellant suspected the fidelity of his wife, therefore he committed the murder.
Yes. Yes. That is one thing, sir. Then
That is the only submission, that is the only point I have found from this judgment, Your Lordship.
all right. Who's for the Mr. Katke, you're there or
23.
No, some part of the documents are not available here in this paperwork regarding scientific evidence, etc.
but sir, anyway, sir,
Yes.
you read
Yes,
the
yes.
judgment of the trial court, will know the circumstances.
May preamble to go through the LCR for some time.
All right.
You may pass to Bangladesh. You may pass to him.
All right. Pass.
After launch, Your Lordship.
After lunch.
Supplementary list item number 24.
May I please, Your Lord? Appellant is convicted under section 302 and is undergoing imprisonment for life and has already completed 11 years of imprisonment, my lord.
Right.
And as my lord, as per the FIR story is concerned,
yes,
which is one Sibbatsa Raut filed an FIR. It is alleged that about 10 p.m. he came from his work and found that in front of his house, one Bharat Bahadur, the deceased, was lying with several bleeding injuries on different parts of the body. And when being questioned, he replied that both the accused persons, Punna Patra and Jatin Das, have caused such bleeding injuries. Accordingly, he filed an FIR before the police station. Well, this FIR is filed on the behest of the police station. I am taking to your lordship to the evidence of the cross-examination of PW2, my lord.
Yes.
My lord, I returned back from home at about 10:30 to 11. I had gone to the PS at 12 o'clock to file the FIR. I have only stated to the police that I saw the deceased lying injured in front of my house, that the police came with me to the spot. He was taken to the RGS for treatment. On the next day, I scribed the FIR, your lordship. On the next day, I scribed the FIR as per the instruction of the police. As per the direction of the police, I scribed the FIR that the accused person had assaulted the deceased by Paniki and life. The accused Punna Patra has not stated before me anything involving himself in the crime. Nothing has been seized in my presence, but I put my signature at the PS as per the direction of the police. This my respectful submission is that on the direction of the police.
That's different, sir. That direction is not dictation. Direction is different from dictation.
Yes, sir. They have dictated to
they not use the word dictation. They use the word direction.
Yes, yes.
You go to the police station, the policeman tells you, you have to write here, you have to do this, you have to do that.
No. He specifically stated, my lord.
What?
I scribed the FIR as per the instruction of the policeman.
That's right.
Yes.
This is not actual dictation, sir. English language has to be used carefully.
As per direction of the police, I scribed the FIR and
direction, instruction is different from dictation.
Yes, ma'am.
Like let's say the policeman himself writes, then says you sign it here. That's
the policeman is not supposed to dictate you write such and such. So it's doubtful, man. The FIR itself is doubtful.
Anyway, all right. Any other?
Next, the learned court, there are a lot of, my lord, no, this is based on circumstances. Nobody is a witness to the crime. Nobody has seen that the accused person, that the deceased was assaulted by a knife.
What is the first important circumstance, sir? What is the first important circumstance?
First important circumstances is that nobody has seen the crime.
You are forgetting, sir. What is the first important circumstance?
Dying declaration, I am coming to it. A dying declaration is there, and also section 27 is leading to discovery. My lord, your lordship may kindly see a dying declaration. The learned court below had made an error below, believing the evidence of PW1. The magistrate who recorded the dying declaration, which was recorded 4 days prior to the date of the deceased, my lord. And the dying declaration recorded is without doctor certifying it. That the deceased was in fit state of mind or something like that. He has not. No doctor has given the certificate. The same is a requirement of law, which has been put forward by the learned people who conducted the case, my lord. Your lordship may kindly see page 11, my lord. The defense counsel has put a question during cross-examination that the executive magistrate has not certified through a physician that the deceased was in fit state of mind, recording the dying declaration. The learned defense counsel submitted that this is a requirement of law, without which the dying declaration cannot be taken to be authenticated. But the learned court, that I have carefully gone through the dying declaration and the evidence PW1 wasted. The essence of dying declaration is both accused persons have assaulted the deceased, which he stated in the sound state of mind. Thus, even if no certificate of the physician is given, the worth of dying declaration cannot be understood. And your lordship may kindly see the deposition of PW1, the executive magistrate. Your lordship may see the cross-examination. The order of the sub-collector was received by me at 11 a.m. on 3/5/2002. I proceeded to a 1:30 p.m. as the deceased was not in a conscious state of mind. I returned back and again went to RDH at 4 p.m. I have not certified through physician that the deceased was in fit state of mind. But as a rational human being, I have studied his mind, and thereafter I recorded the dying declaration, noting down such a state of mind was not certified by the physician of the nothing down as such a state of mind by me was not certified by the physician of the RDH. It is not a fact that the deceased was not in a fit state of mind. And to answer my question, I have not been examined by the IO. It is not a fact that I ordered to support the IO, and I have given such certificate that the deceased was conscious state of mind. My lord, at the 12 p.m., 11 a.m. On 3/5/2010, he was summoned by the sub-collector to record the dying declaration. And he went, but he found that the deceased state of mind was not in a position to give diagnosis. At 4 p.m., he suddenly became conscious and dying declaration was recorded. This is very much improbable and also suspicious, my lord, about the dying declaration, my lord. dying declaration. To this, here also to this I have enclosed one. I have reported decision in 2010 45 OCR page 210. Srimati Saudamini Acharya was state of dying declaration is a weak piece of evidence. As usually, court should seek some corroboration from independent source. If the dying declaration is tainted with some suspicious circumstances, it should be thrown out wholesale. Requisition was addressed to ADMO, but it never reached the ADMO. PW5 recorded dying declaration without direction for reasons of urgency, and Depot 5 is not accepted. No signature of the witness was obtained. In the declaration, neither signature of LTI of the deceased was taken. Deceased suffer 100% vulnerable. Held dying declaration is extremely suspicious and is not worthy to believe. The said decision I will enclose in my note. The second thing is that leading to discovery, my lord. Section 21. The IO PW 15 in the chief stated that the accused Puna has confessed the offense and intended to give recovery of the weapon of offense from a teak jungle to his house. He also stated in the confessional statement was recorded in presence of the witness and led to recovery of the weapon of offense, which is concealed in a heap of stone of jungle. It is submitted, I has not proved the signature of the witness, not the witness were produced before the court for examination. The learned court has opined that even the signature of the independent have not been proved, but there cannot be any reason for why investigation shall not be accepted at Turpan. I am placing the finding part of the honorable court, my lord, trial court, my lord. Now, page 10 of the note paper book. The evidence of the no, this is not page 10. It's page 12, my lord. Coming to the evidence of the investigation officer, it is found that while the accused person were in custody, accused Puna Bhagan confessed before him that he has committed the offense and intended to give recovery to the weapon of offense from the teak forest located nearer to his house. The evidence of the investigation further reveals that the confessional statement of the accused Puna was made in presence of witness, and thereafter he led them to the witness and gave recovery to the offense, weapon of offense, which was concealed in a heap of in a stone in a jungle. The confession statement is not proved under section 41, which has also been made in presence of the witness. Both here it is admitted that it has not been proved in presence of the actor. Both the accused persons have put their signature in the confession. An investigation officer under section 27 of the Evidence Act, even if the signature of the witness have not been put, but it cannot be any reason why the evidence of the investigation shall not be. I have carefully perused the statement of the accused person section 27 was there, and I am in view that both the accused person and voluntarily given statement. And I invite your lordships to evidence number of PW 15, my lord. Your lordship, kindly see. Evidence of PW 15. The IO. Examination of the cross-examination, my lord. The chemical examiner report has not been received by me yet. The seizure weapon of the offense, another and other properties have not been produced in the court. My lord, he has not produced the weapon of offense before the trial court. It is not the fact that the incriminated articles are not seized from the possession of the accused Bhagwan Patra and Punu. And he has not made and confessional statement and recovery of any article. It wasn't a fact that I have submitted a functionary charge sheet. To this, my submission is that this the investigation of the IO is totally a functional matter, and he has not produced the weapon of offense. Neither he has with the weapon of offense, which was which led to discovery, is also not supported by independent. No independent witnesses supported it, my lord. And the cross examination, he admitted he has not produced the weapons, but for the trial court and the chemical examination report. So it creates a serious doubt as to the recovery of the weapon. PW 14 also conducted a surgery stated that there is no paper to suggest that any weapon of offense was produced before him by the IO. Also, PW 11 stated that there is no mention in the requisition letter as to the seized weapon of offense. It is also submitted in a decision reported in 2004 to OLR 82 Bisikishan Pujari, Section 22 Evidence Act, confession by the accused before the police while in the custody of not to prove against him unless it is made immediately before the magistrate. The chemical report given by the RF lab stated that the origin of the blood has no opinion, and as to no blood group was also given. As to recovery of the weapon of the offense, forwarding report, it states that the weapon is concealed under the beneath of heap of stone, was recovered behind the house of Punapatra. But in the chief, the IO states that the recovery of offense is from the teak jungle. PW2 states that in the direction of police is typed up. And also the PW said that nothing has been seized from the accused in presence. He also put his signature as per direction. This creates a serious doubt in the investigation of the police, which has not been done in a confectionery matter. The learned trial court, without scrutinizing the evidence, believing on the confession under Section 27 of the Act, stating that the accused person voluntarily given in the presence of the witness and investigation of a convicted the appellant under Section 20. To this, I have a decision reported in 2017 Criminal Law Journal, 422 State versus Orissa versus Mata Munda. Evidence as to recovery of rape and murder, alleged discovery of weapon of offense, school bag, ballpoint pen, books, and of the minor deceased at the instance of the accused. Recovery not produced before the trial court and not proved. Witness cannot be attested. And there is also Supreme Court decision about lackluster manner of the IO investigation. Year 2016 Supreme Court, page 5231E, Mahavir Singh versus State of MP. Murder investigation officer is expected to be diligent, truthful, and fair in approach of investigation carried in a lackluster manner. No firm, sincere effort part of the investigation needed to deal in spirit to bring home the guilty of that conviction passed by the High Court statement. First, then, also, my lord, neither in the affair nor the witness have stated they have seen the incident and the offense. It's either one or both the accused person attacking the deceased by knife on PW 16 in the that the inquest report is mentioned that both the accused have killed the deceased with a knife, which is contradictory to the statement made by the deceased in the dying declaration. That the learned court below the judgment that the PW 16 in the evidence stated that the inquest report mentioned that both the accused persons have killed the deceased by knife. The learned court opined that it is a solid piece of evidence. To this, it is expected to submitted that PW 16 is not an independent witness. He is an interested witness. He is not an eyewitness to the crime and a hearsay witness informed by the sister-in-law. He has not been examined by his statement contradicts to the accusation. So the learned court acted in a casual manner in relying on the evidence of the PW 16 convicting the accused. My lord, all the evidence, all the witnesses are hearsay evidence, but the learned court, without scrutinizing them properly, has convicted the accused, my lord, the appellant, my lord. Also, Lordship may, I am placing para 7. Now it is seen whether the accused person are responsible for the injury. In this case, PW scribed a FIR. We found that the deceased was lying in the ground in front of the civilian. And he has proved an FIR and a FIR by he also corroborated.
Don't simply keep reading.
No,
Make your point.
I am coming to medical evidence, my lord. Medical evidence also states that there are two parts of the story, my lord. One is that the accused committed was admitted to a hospital on 3/10 to 2010, my lord. And also, and then second time he came to hospital with another injury, my lord. Two injuries they are there. I pray Lordship may kindly, there is page 43 of the paper. PW 11, my lord.
Yes.
On 7/5/2012, the policeman visited on the I conducted the postmortem of the dead body.
Why don't you make your point, sir?
Point is that first set of wound was surgically repaired, my lord. Then second, so the fresh wounds. There was 3 fresh tears of the omentum and blood vessel near the repair omentum, which was caused by hemorrhage into parietal cavity. Parietal cavity consists of blood and clots of the corresponding to 1 or 8 liters.
What is the point you're making?
Point of making that I invite your lordship to the witness of PW 7, my lord. PW 7 states that police.
Sir, what is the point you're making, sir?
Point is that the accused persons have been implicated in a false case.
Oh,
it is he is dead by falling from a wall of a Marwadi gentleman.
I see.
Or the police rounded up these two fellows and made a false case. This is the point I am going to harmonize. Here, PW 7 evidence has not been taken into account. Deceased is my nephew. He is not the brother-in-law, Salah. I have not stated in Exhibit 7 which was my Salah. The deceased who was cured after treatment in RGS and thereafter he went towards the civil township and while jumping fell down on the dray of a Marwari gentleman and died. Thereafter, inquest was held. And this evidence of 7 was not. This is also supported by PW 11. He says that fresh wounds. There are 3 fresh wounds, tears momentum and blood vessels near the repair momentum, which was caused by hemorrhage, which is parietal cavity, and also. So also another evidence. My lord, your lordship may see PW 13, my lord. PW 13. On 3, this is one doctor giving deposing. On 3/5/2010 at 2 p.m., 2 a.m., the patient Bharat Bahadur was admitted on other come. He was under treatment of Dr. P.C. Mahapatra on 5/5/2000. I have attested the during the operation. I have assisted Dr. Mahapatra during the operation. The findings were noted down by me as per the dictation of Dr. P.C. Mahapatra. This is the report, marked as Exhibit 13. My lord, on the cross-examination says that on 6/5/2010 at 1 p.m., the patient was absent from the bed. This matter was intimated by us to the police. As per our report, again, the patient was brought to the hospital at 2:20 p.m. The report indicates that the deceased has fallen in a drain of the Raulkela civil township at 2:20 p.m. that day. As the report indicates, the deceased was dead because the main organs were not functioning at the time. But this part, this evidence was also corroborated by Dr. P.C. Mahapatra. On 3/5, I examined the patient body. It was caused of stable injury and lower such and such. I conducted a second operation after the patient condition improved. Dr. Kausalya Pradhan has retained the operation note as per my direction. This is my report exhibit 8 sheet 13/2. My signature. It consists that the report of Dr. Margaret 13 and other doctor. There is no paper to suggest that any weapon of offense was produced before me. Well, the deceased died by falling from a wall. There is also no direct, there is no evidence, absolutely no evidence that the appellants caused injury by stabbing by knife or a paniki to the deceased persons. Absolutely no evidence is there. All evidence are contradictory to each other, and there's a lot of infirmity in evidence of 1, 2, 3, 4, 5. All are interested witness, and neither of them has seen the occurrence. So, benefit of doubt may be given to the accused person.
May I please, my lord?
Continue after lunch. All right.
Lordship.
Lordship, in a compelling situation, I want to make a mention before Lordship. In fact, what I have informed registry, tomorrow regular bench of Lordship is not functioning. And we have challenged the appointment of notification of a DC judge, notification of the Noyagarh DC judge, where Miller, just for direction of the state government to fix the upper age limit 38, he has fixed to 32.
They have already, I must tell you, we're already issuing instructions. We are also carrying out a formal amendment. We're already issuing instructions for them to issue fresh advertisements with a higher age limit. So all this will be unnecessary infractions it will become. But it's totally unnecessary, sir.
Lordship,
Just wait for tonight. All right?
Lordship, oblige, Lordship.
Supplementary list item 24.
My lord, before my lord takes up the list, my lord, a matter has been mentioned. My lord, that is WPC number 2660 of 2011. That is not in the list, but that is mentioned to be taken up at 2. But because I am filing my count today.
No. That's right. That DRT matter.
DRT matter.
Yes, ma'am.
My lord, that's why, my lord, I pray any day in next week.
My lord, just show us the counter, what you're saying in the counter. Let us see what is there. Give him a copy.
My lord, I have just now received.
I have served.
Just now I received the copy.
All right.
No factual aspect. In fact, these are all question of law.
What are you going to lose by providing them these documents?
But these documents, this
is there any secrecy?
Closed loan account, long since closed.
No,
But
if
these
you
are
have
not
the document you provide.
But these are not traceable at all.
Where have you said that?
But that I have stated.
Where?
But towards last, paragraph 6. Besides the above, it would be pertinent to mention here that this branch is functioning in a tenanted premises right from the date of its opening on 4/6/81 at Motiganj Bazaar, Baleshwar. The branch shifted on 18/1/16 to its present tenanted premises at Sanjay Heights.
So the documents are not even traceable. What are we?
My lord, my humble submission, my lord, your lordship may kindly have a glance that in this petition, he has second para, he has clearly mentioned that I have not deposited 10 lakhs. The core question is, I have
Sir, that is not the question, sir.
But my lord,
your writ petition is only on these documents.
My lord, my lord. Para 12, your lordship may kindly have a glance, page 6.
Para 12 of what?
My lord, here, the main thing is before opening of my original loan account, 5 to 6 months before, they have opened a dummy account.
Sir, we are not on the merits as far as this writ petition is concerned.
My lord,
all that the DRT will look into. Here you only want documents.
Yes, my lord, only documents.
So the documents DRT said is not necessary.
My lord, it's
even if we ask them to deliver documents to you, they don't have them with them. Just come to para 6.
My lord.
So what are we going to do?
My
you can't ask them to create documents which they don't have.
No, my lord, it's not creation, my lord. My original loan was of about 10 lakh CC limit. But unfortunately, in that loan account, around 36 lakhs 50,000 has been disbursed without my knowledge, and that had been transferred to the dummy account and it was been withdrawn. That is not up to my knowledge, my lord. So how before existence of my original CC account, a same person, same name, 6 months.
You examine the witness. That's the only thing you can do. What else can you do?
My lord,
if there are documents, if there are documents, we can ask them to give you documents.
Yes,
if they don't have, we can't ask them to.
Yes, my lord, he can give the statement of accounts because, my lord, when I have not received that amount, am I liable to pay? Your lordship has to decide
But the allegations made will make it clear. But she says she has signed, put her signature
my
on
lord,
blank forms and
before opening
checks,
of my
etc.
original account, a fake account was already
And
opened
that has been created on the
5
basis
months
of
before.
that.
So I have only taken a sum of rupees 10 lakhs CC limit. How is it all of a sudden it has risen to more than 40 lakhs without my knowledge?
Kindly see the writ petition itself, what she says.
Because the same account is also in my name. Who has created it? Who has found it? Who has taken the money? I have not disbursed it.
All right. The challenge in the present writ petition is to an order dated 3rd January 2011, passed by the Debt Recovery Tribunal, Orissa, Cuttack, bracket DRT, rejecting an application filed with the present petitioner under section 17, bracket 1 of the SARFACI Act 2002, seeking directions to the opposite party bank to produce 9 documents. While directing notice to issue the present petition on 21st January 2011, this court had stayed the further proceedings in diary number 222 of 2010 pending for the DRT Cuttack. Paragraph. An earlier order passed with this court on 31st March 2021, disposing of the writ petition, was set aside by the Supreme Court of India by its order dated 5th May 2021 in Civil Appeal number 3669 of 2022. And this court was asked to decide and dispose of the main writ petition within 3 months. Paragraph. Pursuant to the order passed with this court in the present petition thereafter, on 4th July 2022, a counter affidavit had been filed by the Chief Manager of the State Bank of India, Motiganj branch, were inter alia specific to the documents in question. It is stated in para 6 as under. Reproduce the whole of para 6 of the counter affidavit paragraph. In order that there should not be any further delay of the proceedings before the DRT, the court directs that as and when any of the documents, as any or all of the documents as sought by the petitioner are able to be located by the opposite party bank, copies thereof should be produced before the DRT with copies to the petitioner here, as long as the proceedings are pending before the DRT. Full stop. Since the claim of the bank is that the documents are not traceable as at present, the proceedings before the DRT need not get delayed and can proceed in accordance with law. Full stop. With the above observations, the interim order is vacated and the writ petition is disposed of. The impugned order of the DRT will stand modified accordingly.
But his stand, that itself indicates
you see,
he has put her signature everywhere.
That it has not expressed any view on the respective contentions of the petitioner and the opposite party bank on merits.
Urgent copy.
Urgent copy as per rules. All right. A copy of this order be sent to the DRT concerned forthwith. Yes. But we'll finish the part third. We'll finish this part third first.
Item 24.
Orissa. Yes, ma'am. Pardon to mention. May I please, my lord?
Yes, please.
I am for the appellant number 2, my lord.
Yes, just put the mic near your mouth, madam. You can just draw the mic too.
I am for the appellant number 2.
Yes.
And in this case, Jiten, the appellant, had no role to play in this case. And there is no material, absolutely no material against him. And he is released on bail on 24/6/2013. And he has also not contacted with me, but the case has been came out that I'm arguing with, and I'm also supporting all the argue and decision and points with my colleague friends. By my points are that in the PW3 has stated, my lord, I know the accused persons. So also I know that this is Bharat Bahadur. The incident took place during last summer season. On the night of incident, while we were sleeping, we heard hue and cry and opened the door. And at that time, the deceased rushed inside the house and asked for water. After asking me to provide water, he became unconscious in front of my house. His body was suspended with blood and his intestine was also coming out from his belly. My lord, my point is that if such type of accused is such type of serious and very unconscious mind and serious ill condition, how can he utter a word and how can he narrated his incident, all these things? My point is that. And number 4, PW4 has also stated, deceased is my younger brother. In the night of incident, my younger sister telephoned me and stated that my brother has been assaulted severely and sustained bleeding injury. On the next day, I came to RGH Raulkala on my query in the hospital. My brother stated before me that accused Gunapatra stabbed him by knife. He also stated that the other accused Jiten was present with accused Gunapatra. I advised my brother to take rest and doctor came and advised me for operation of my brother. He had undergone operation and thereafter he died subsequently. This. Then again, my lord, PW5 has stated that I know the disease as well as accused person. The incident took place on 6/5/2010. In the night, the deceased rushed to my house and told that the accused Puna assaulted him by means of knife, and he demanded a weapon from me to take revenge against the accused, to which I refused. After a search from my house, he took away a knife and rushed outside to take revenge against the accused persons. Cross-examination has been defense. He stated that in the cross-examination, deceased usually take liquor. There are numbers of criminal cases on the allegation of assaulting other by dangerous weapons. The deceased came to my house and he has no injury, and that he had taken a knife to take revenge. That's all. Did not happen. And my brother has also stated that deposition of the deposition number 11, that and the seizure list, and that the third para, my lord, that is describe all the. It is also in the cross-examination defense. If the deceased would have continued in the treatment in the hospital, he would have survived. At the time of the submission of the PM exam report, I had not verified the medical report of Raulkela, as those were not sent to me for my verification. The deceased died due to the injury that was caused to him on the second stage of the incident, as become he saw running away from the hospital for some reason. My lord, these are the points that the case is. Nobody has seen the incident, and he has also. They have said that they have no direct knowledge, and this is all the other hearsay and very peculiarity, and all the controversies is there, and so. He has in the appellant number 2, there is nobody has only stated that the 2 persons are accused, but nobody has seen and nobody, not the material, and the medical report also says, and the IO also, and the first PW1, the executive magistrate, which has been my learned friend has already been pointed in submission that the without the certificate of the doctor, he has the recorded the dying declaration. This is also a demerits and all the points. This is not a my lord. All the points and all the false. I'm telling that false statement and false that the case had been based. So my submission is. If admitted.
All right. I have left one point, madam. There is no motive in the crime.
Motive is intention.
Decision of your lordship reported on 2021 OLR 1072 3. Circumstantial motive. In absence of proof of motive can be critically fatal to the case of prosecution held. There is a distinction between the case of direct evidence where motive may not be critical factor, and the cases of circumstantial evidence where motive does constitute a critical link in the chain of circumstances. Therefore, as an important link of chain of circumstances is not proved, as none of the links of the chain of circumstances have been established convincingly by the prosecution, consequently, the court is satisfied that the accused is entitled to benefit of doubt. Accordingly, the impugned judgment trial court is hereby set aside. The accused is acquitted of Section 302 IPC.
Yes, who's for the state?
Because here the executive magistrate was in whose presence the dying declaration has been recorded. Initially, my learned friend has submitted that there is no endorsement to the extent that he was in a fit state of mind to record to give the dying declaration. That part has been decided by Lordship in another case in Anjali Raut versus State of Orissa in JCRL number 88 of 2006. This is your Lordship judgment. Your Lordship vividly dealt with all the judgments those have been referred, including Lakshman versus State of Maharashtra, 2002 volume 6 SCC 710, where it has been stated that the Honorable Apex Court has held that a certification of a doctor is a rule of caution, and therefore the truthfulness of the declaration can be established otherwise. In the decision, Supra's dying declaration was recorded by a magistrate, and there is no certification by the doctor regarding the fitness of the victim's state of mind, and in that context, held that it would not ipso facto render the declaration unacceptable, inasmuch as its evidentiary value would rather depend on the facts and circumstances of the case. However, in the present situation, will obtain is the doctor who recorded the declaration of the deceased, and therefore he was the right person to assess the mental condition of the victim. Here, in this case, occurrence has taken place on 2nd May 2010. FR has been lodged on the next day, and the deceased died on 10th May. The 7th May. Because on that day, postmortem has been conducted, which is clear from the deposition of PW 11. Yes, page 43, PW 11.
Yes.
On 7th May 2010 at 12:15 p.m. on police requisition, I conducted PM over the dead body of the deceased. So the deceased was survived for 5 days after being assaulted by the accused persons. He has been stabbed mercilessly, as because several blows have been given on his person. 1, 2, 3, 4, 5. Plus 5 injuries are there. Loss will find from page 43 of the paper book. And one is antemortem inside wound, that is on lateral side of upper part of the right wrist. Then the 2 surgical drain inside wounds on the both lower anterior lateral abdomen wall. Then 1 right paramedian incision wound of 17 cm long. You also can understand how long it is. From level 2 is below umbilicus to right subcostal region with full muscle deep. It is for repair of 2 anterior abdominal stab wounds. Likewise, 1 repaired inside wound, and then 1 stitched inside wound. So many injuries are there, and as because 5 days after he has died, and also as my learned friend just pointed out, he has also talked to some of his relations, even in the hospital. So he was very well able to speak before the magistrate, because magistrate is an independent person. He cannot be expected to be biased in any way, because he cannot carry any animus against the accused appellants. And he has categorically.
What is the actual text of dying declaration?
That is Exhibit 1. Exhibit 1 will also be fine. Because from the judgment I can read, because that exhibit is not with me. That is paragraph 8, page 10 of the paper book. The evidence of executive magistrate PW1 and the investigating officer PW15 are most important, inasmuch as PW1 being the executive magistrate has proved the dying declaration by Exhibit 1. He has recorded the dying declaration of the deceased in question and answer form, and to his question, the deceased replied that accused Kuna had caused the injuries on his person. In the question number 5, the executive magistrate has also recorded that the second accused Jatin has also assaulted the deceased by a poniki. That is also a sharp cutting weapon, usually used for vegetable cutting. The executive magistrate PW1 has categorically stated in his evidence that at the time of recording of the dying declaration, the deceased was in good state of mind. And to his question as to who has caused the injuries to him, the deceased replied to PW1, that means executive magistrate, that both the accused persons have caused such injuries on his person.
All right.
So it is very, very categorical, boss. And it is true and voluntary. It cannot be said that it is involuntary.
So this whole story of falling in the drain and all that, he says the man fell on his own. He tried to escape and fell into the drain, and that's how he died.
That PW7, he happened to a nephew of the appellant. That is, in the cross he has stated, quite absurd. He cannot believe being the nephew.
What about A2? She says that he's not even responsible. He is nowhere involved.
Because
the other one, Jitendra, Jiten Kumar.
As my learned friend has just submitted, he might have been unconscious for some time. But when he was taken to the hospital, So in the hospital, because he has survived for 5 days, and in the hospital he has also talked to some of his relatives. With the next statement she has read, he has talked to some of his relatives. So there he has given given his statement. The dying declaration he has given in presence of the magistrate, and that has been recorded.
What about motive?
Plus motive is
Para 12.
Yes.
The court says motive is not proved.
Plus always motive remains in the mind of the accused. Even motive cannot be proved. Plus also I will cite some judgments to the lordship. I will give it in my note of submissions. Always motive cannot be proved because it always remains in the mind of the accused. There are also cases where motive cannot be proved, but still it cannot be said that entire prosecution case can be brushed aside. So plus that so that aspect is concerned. I also watch some relevant judgments of the Honorable Apex Court.
All right.
Always motive is not required to prove even if in circumstantial evidence.
All right.
Because when there is clearly in the dying declaration the deceased who is no more, why he will take the name of some other persons who are no way involved in the crime?
The seizure of weapons also he criticized. He says the witnesses have turned hostile. Seizure witnesses.
Seizure witnesses have turned. Yes, no. That also that hostility pass. So far, even if that some seizure witnesses have turned hostile, then also the evidence of the IO can be made admissible. The IO cannot disbelieve. The IO is also a public officer. He being a public officer, always his evidence cannot be set aside. And it is always not required that he should be corroborated. Here, dying declaration being voluntary and being very clean and having been recorded in the presence of an executive magistrate who is an independent officer, that cannot be discarded. That's the prime piece of evidence, which is there very well there. And recently also, I am just passing on the judgment of this Honorable Court. That is 2022 volume 4 SCC page 741. State of UP versus Birapal. I'm just passing on because I'm sending it for a Xerox. There also this statement before the magistrate that has been dealt with by the Honorable Apex Court, and if it has been recorded in the presence of a magistrate, then that cannot be brushed aside because that magistrate doesn't have any animus towards the appellants. He being a responsible officer of the government, he has come over only to see whether it is being recorded rightly or not. That was I will give the judgment, and in my note by submissions, the entire judgments I will provide to Lordship.
Yes, sir.
My respectable submission is that my learned friend says that the evidence of the IO cannot be discarded. My respectable submission is that he has not produced the weapon of offense before the trial. He has not examined independently as to the seizure of the weapon. So also there is discrepancy in the recovery of the weapon. One in his evidence he says that it was recovered from the back of the house, and sometimes he says in the evidence he says in the jungle. Then which is correct? And as to dying declaration, as I have pointed out, the PW1, he says that he proceeded to, by the order of collector, he received me at 11 a.m. on 3/5, proceeded to RJ 1:30. At that time, deceased was not in conscious. I returned back and again went to her. If the deceased was not conscious, and he became certainly fit to give at 4 p.m. dying declaration. This is very much
if
probable.
The intestine is if the intestine is come out,
when the intestine come out,
such a serious condition, several persons have stated that several accused, several PW has stated that, and different very questless statements are also different. So investigation is I was not investigated properly, my lord. So many controversy and so many peculiar statements are there, my lord. All the statements are differ from another.
Also, PW 11 in his cross-examination states that if the disease would have been continued in the treatment in the hospital, he would have survived.
That is
at the time of submission of PM examination report. I had not verified the medical report of the RGS. as these are not sent to me for verification. The deceased died due to injury that was caused to him due to second stage of incident, as because he was running away from the hospital for some reason. From this, it is proved that he died due to second stage of injury, not due to first stage of injury.
Yes.
Respectful submissions.
Or orders reserved.
One paragraph I may be permitted to read from the judgment report in 2012 for SCC, page 722. I'm just reading the paragraph. We are certainly not indicating that despite all this, the statement of the police officer for recovery and other matters could not be believed and form the basis of conviction, but where the statement of such witness is not reliable and doesn't inspire confidence, then the accused would be entitled to the benefit of doubt in accordance with law. Mere absence of independent witness when the investigating officer recorded the statement of the accused and the article was recovered pursuant to thereto is not a sufficient ground to discard the evidence of the police officer related to recovery at the instance of the accused. Similar would be the situation where the arresting witness turned hostile, but where the statement of the police officer itself is unreliable then it may be difficult for the court to accept the recovery as lawful and legally admissible. Your hospital can kindly find the evidence of the IO, plus no cross-examination has been made. Nothing has been put to him regarding to even to make his evidence deposition untruthful.
It's okay. We've heard. We say orders reserved to be open to the parties to file their respective written notes of submissions within a week. Or
today I'm filing.
Or prison matter.
Matter fixed for 2 p.m.
My lord,
Item number
I
11.
really need to time, my lord.
Yes, please.
Item number 11, WPC 6610 of 2006.
My lord, in this case, in terms of the order of this honorable court last date, I have filed an affidavit yesterday.
I think Mr. Chabra is there. Yes.
Yes. Chabra is
Good afternoon, sir.
And Mr. Smruti Mahapatra, my lord, the Deputy Secretary of Orissa State Legal Services Authority, he is there also.
Yes.
Sir, I'm there.
Yes, sir. Yes.
Good afternoon, sir.
Good afternoon.
In fact, I have given a convenience note. My lord would see regarding overcrowding, much has improved.
All right.
Except these four odd jails which I have listed.
Right.
But there is one development in the Supreme Court which may help us. This is what I think, subject to what the court feels.
Para 4, regarding overcrowding, para 4 of my reply.
Yes. From there, I have taken into account their affidavit. These 4 jails, it is in excess. Sub-jail Jajpur, Aska, Dharamgarh, Kodara is there as per their affidavit.
Right.
What they have been able to do is they have been able to shift, for which the numbers are now looking okay.
All right.
So if my lord would see this recent judgment dated July 11th.
Right. Bail one, about bails and all that.
About bails, the conclusion is at the last page, paragraph 73.
Yes.
This may be relevant in the context of, I have given 2 copies for my lords.
Right.
73B, the investigating agencies and their officers are duty bound to comply with the mandate of section 41 and 41 capital A of the code and the directions issued by the court in Arnish Kumar. Any dereliction on their part has to be brought to the notice of the higher authorities by the court, followed by appropriate action. So this is something which we were actually facing that problem. So this may help reduce the overcrowding here. If this is followed here, then see, my lords, the courts will have to satisfy themselves on the compliance of section 41 and 41 capital A of the code. Any non-compliance would entitle the accused for grant of bail. Then D, my lords, all the state governments and union territories are directed to facilitate standing orders for the procedure to be followed under section 41 and 41A of the code, while taking note of the order of the High Court of Delhi dated so-and-so, in writ petition number so-and-so, and the standing order issued by the Delhi police, that is standing order number 103 of 2020, to comply with the mandate of section 41A of the code. Then E is regarding that forwarding of accused there need not be any insistence on bail application while considering the application under section 88, 170, 204 and 209 of the code. F, there needs to be a strict compliance of the mandate laid down in the judgment in the court of Siddharth Malaj. The state and central governments will have to comply with the directions issued by this court from time to time with respect to constitution. This, my lord, may skip. The high courts are directed to undertake the exercise of finding out the undertrial prisoners who are not able to comply with the bail conditions. After doing so, appropriate action will have to be taken in the light of section 440 of the code, facilitating their release. While insisting upon sureties, the mandate of section 440 of the code has to be kept in mind. An exercise will have to be done in a similar manner to comply with the mandate of section 436 capital A of the code by dealing with the district judiciary level and the high court as earlier directed by this court in Bhim Singh, followed by appropriate orders. K, bail applications ought to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise, with the exception being an intervening application. Applications for anticipatory bail are expected to be disposed of within a period of 6 weeks, with the exception of any intervening application. Then status reports and all have been. This has been circulated all across. So this is something which may help us in overcrowding so far as that Arnesh Kumar, because that's what was the stumbling block for us.
Yes.
So this is something which I have included in the note itself. Then, my lords, the DG prisons has been very kind enough to actually look into the issue of mental health.
Right.
There are around 800 odd. He may be able to apprise more on that, because what we see is that the health department is slightly sluggish on this issue.
Right.
Including visits of doctors and psychiatrists.
Yes.
He has been requesting them in the meetings and all, and even the Home Special Secretary Home, he has also been pursuing it.
Right.
But probably there is some hitch in that area.
Because from what I understood is only in Rourkela they have one psychiatrist visiting.
Correct. In their affidavit they have given, if my lords would see the government's affidavit.
Yes. Page
regarding 14. The visits.
Yeah. Page 14.
My lords. This he has been highlighting also in all the meetings of the committee.
Right.
My lord may see the visits.
I know, they're all in single digits.
Yes. And here I think they have to put the act together. Like there has been requests by the DG prisons to the health department.
What happened to the prison development board?
Yes. There a lot of improvements have taken place. The first meeting has come in. That's at page 16.
Right.
All these, if that can be fast-tracked, it will really help, my lords. Page 16, improvement of health facilities.
Right.
That was the first agenda. Here, if I may be allowed to give a few facts and figures.
Yes.
Now, so far as the regular doctors, this is what was shown to the board.
Right.
So far as regular doctors are concerned, there are 35 sanctioned posts.
Right.
Out of that, I think 4 are there. So there are 31 vacancies so far as regular doctors.
Mm.
Then contractual doctors, the sanctioned post is 73.
Where are you reading?
This is a write-up, my lords, which I had collected. Since it was for the board, I'm just reading it from the...
All right. So there are
huge vacancies. In short, there are huge vacancies.
So what does the prison development board say on that?
That, my lord, they say that we will look. My lord may see that is at page 16. Proposal. So normal language, my lords, they have used.
Right.
And this is the resolution passed in the high level meeting.
Yes.
And that is only on 25th July, just
3 days ago.
2 days ago.
No, but on this filling up of posts.
That, my lord, may see the page 17, clause B. The board considered the functional requirement of female nursing orderlies in prisons with high female inmates and directed that specific proposal for hiring female nursing orderlies on outsourcing basis be submitted. Similar proposal for additional male nursing orderlies to be submitted for 20.
No, but what about doctors then? So this is nursing orderlies.
Doctors and all.
Can I just?
Yes,
Yeah.
It was his proposal actually.
Because he was present in the meeting, so he
Right.
can better appeal
Yes,
the
Mr.
lordship.
Yes.
Sir, I am the member convener of the board, and
Yes.
finally on 25th. And I am happy to report that certain positive developments have taken place.
Right.
First of all, regarding the doctors.
Yes.
So we have lot of vacancies because the contractual doctors, which we were allowed to hire, we were not able to hire because somehow they were classified as part-time doctors. Rather than the jail doctors, the posts were classified as part-time doctors rather than full-time doctors, as it should have been. So there was an anomaly because of which this part-time doctors were only allowed remuneration of 25,000 per month. And the regular doctors, if we were contracting, they would have been given 55,000. Because of this, actually, the contractual posts were not able to be filled up because no doctor was willing to work at 25,000. So we had moved the finance department, home department had agreed with us. And actually in the present development board, this was actually agreed to by the finance secretary. And I am happy to report that that proposal has been concurred. Now orders are going to be received in a day or so. This will actually help us in hiring contractual doctors at rupees 55,000 per month. So I am hopeful once this order is coming in a day or so, we will be able to fulfill the doctor's vacancy to a large extent.
All right.
Yes.
Second aspect was about that female orderly, because when I visited some prisons, we saw that where there are female inmates and they have medical problems, wherever there is a doctor also, it's mostly a male doctor. So they are handled by male doctors, and a lot of male doctors were apprehensive that when we are handling female prisoners, it can lead to a lot of issues because, sometimes they say we have to put in a catheter. So if there is no female, then it can lead to kind of, can be a medical legal issues. Plus, it is also embarrassing to the female inmates. Many of them are hiding their position. So since there are no posts of female orderly, I requested that we should be allowed some female nursing orderlies, at least, so that female inmates, whichever prisons there are high number of female inmates, let's say more than 10 inmates, then we can have a female nursing orderly. If posts are not sanctioned, at least allow us to have them on a outsourcing hiring basis. So this was actually agreed to by the board, and they just said that you submit a proposal, we will allow it. So we are in the process of submitting the proposal. This will go through, sir.
All right.
Similar to the male orderlies also, we wanted increase. So as far as the health thing is concerned, doctor's position is likely to improve in the coming days, but the mental health issues still remain a problem, sir. So if I may take a minute, sir, if I can, do I have a minute to explain the situation?
Yes, please.
Okay, so the mental health issues, the problem is that in the state itself, there are very few mental health specialists. And especially in remote places, the government also doesn't have necessary doctors, psychologists, and psychiatrists. So in this connection, I had proposed in the prison development board that we can maybe have a kind of special backup board here, backup panel here in Bhubaneswar and Cuttack, where there are psychiatrists available, but they are in the private sector. So I can hire them on some remuneration basis. But in the board, they said that let's first approach the SCB Medical College, which has some psychiatrists, and the health department has been directed to approach them. If the college is not able to provide us with requisite number of psychiatrists, then I think this private sector psychiatrist may be hired. So I am now the ball is in the court of health services.
Yes.
DHS, but I don't anticipate much solution because actually they don't really have the numbers. So whatever they do, the doctors may be in Cuttack or Bhubaneswar. How are they going to visit all those remote jails? As it is, the orders have been passed earlier also by the health department that a psychiatrist will visit. But since the sheer number is so low,
Right.
I don't see any improvement. Maybe the court can, honorable court can consider that something the government can be directed in that respect, that the private sector people should be hired on contractual basis. So some direction in this regard, if
Right.
it is there, it
Right.
will help.
Right.
And secondly, sir, I was seeing also the convenience note of the amicus curiae.
Yes.
He has also mentioned about our Orissa prison rules.
Yes.
This mentions clearly that mentally ill people should not be allowed to remain in jail.
Right.
So we have moved actually the courts for shifting them to the psychiatric facilities.
Yes.
If some direction can come, so these people, since there are no psychiatrists, they can actually removed from jail, whether they
Yes.
are bailed out or not. OSLSA has bailed out some, but
Right.
even if they cannot be bailed out, but they should not be allowed to remain in jail. They should be in the psychiatric institutions.
Right. Sir, any development on that building of additional facilities in jails which were overcrowded? I mean, there were some proposals to increase the jail capacity.
Sir, Baleshwar, we have got an increased in capacity of 50 people recently.
Right.
Meeting with the state police housing corporation, which is actually undertaking most of the constructions.
Okay.
So, in that meeting, I will be pushing them to increase the complete the projects.
Right.
So
Because if I remember in Malkangiri, there was supposed to be an additional facility, right?
Malkangiri, it is going to be completed, as I've been told, it is in March 23, sir. But in the meanwhile, sir, if you can see, the position about overcrowding has been resolved to a great extent. Now only one jail which is problematic is Jajpur, where there is more than 100% overcrowding. There are 4 jails which has more than 50%, and there are 12 jails which has more than 20%. Rest of the jails we have been able to redistribute. I agree this is not a perfect solution, but this is the only solution possible as of now, and we are continuously trying to get this redistribution done. Jajpur has been a little bit of a tough nut to crack. We have not been able to make much headway. In Bhadrak, for example, earlier it was more than 100%, 150%, but
Right.
Bhadrak is now only at 30%.
All right. Earlier.
The recent direction, if that is implemented, that may help.
In the Supreme Court.
Of the Supreme Court. If they come up with that circular, that action would be taken, then maybe we may have.
All right.
I was actually stressing this, that since we have Mr. Chabra, somebody who is very keen on this, some of the things which he, in that page 17, emergency response facilities, there what was actually sought for was there's a shortage of ambulances here. So that is also something which is quickly needed, if something can be said about that.
Because they have asked the prison directorate to submit a proposal. That's what the prison development board says.
Yes. Now, probably the next meeting of the board is 6 months down the line.
Oh.
So this can be just, if my lords can observe something regarding this,
Right.
because 87 jails now have 21 vehicles.
Oh. Mr. Chabra, what's the position on that?
No, he's actually on the same page.
I know.
He has given a proposal, so if this can be expedited, that's all I can ask.
All right.
Sir, in fact, we are very poorly placed in comparison to our peer states.
Right.
I have actually visited Telangana jails, and I
Right.
have visited Haryana and other places also.
Right.
We have only 6 vehicles in our jail which have been provided by the government.
Oh, I see.
Another 15 ambulances have been actually provided by CSR activity by private sector.
Oh.
And many of them are off-road also. Because
Okay.
once they have given the vehicle, they are not supposed to provide for repair, etc.
Correct.
There is no government money. So the proposal was well received by the Prison Development Board.
Right.
The issue is only that we send the proposals. Sometimes the proposals take a lot of time to fructified.
Get processed.
So, and there are other proposals regarding manpower also in the Prison Development Board. If the court can see the proceedings of the Prison Development Board,
Right.
in most of the issues which I had raised,
Right.
the response is positive, but it is not time bound.
Hmm.
So we can only submit the proposal and request the government to do. Although in the board they were all in agreement that there is a requirement, but then the government also has its own constraints. We cannot
Right.
push beyond a limit. So
Right.
it's for the honorable court to decide maybe on certain issues.
No, I'm only saying, let's say the shortage is 40% or 60%. The target must be to bring it down by 10%, 20% in a progressive way.
Actually, sir, if you see, I have given the proposal. We have 87 jails and vehicles are only available in
21.
Less than
Correct.
21, actually less than 21. So
Right.
I had actually given a proposal that we should do it phase wise. So
Right.
I am asking only 20 vehicle on hiring basis.
Right.
This time. In the next year, we will ask for another 20. So
Right.
similar with the manpower also. So we
Right.
are not asking them to fulfill all the vacancies or
Correct.
all the shortages, because
Right.
we are also aware of the constraints of the government.
Right.
So a
But
phased
ambulances, there can be no compromise, sir. At least
Actually,
all the
sir,
major jails should have one ambulance each.
Definitely, sir. So if they give us at least 20 now, we
Right.
should be able to cover the major jails.
Right.
And the next meeting of the Prison Development Board, I can push for another 20. So in
Right.
another, let's say 1.5 to 2 years, we will
Right.
be able to cover up all the
All right.
jails. That's the request.
All right. Next issue at page 18 of that board meeting only.
That's what I was just
Manpower
opening-
shortage.
I've seen
So
that.
there also the warder to prisoner ratio is at 1:11.
11, correct.
So that's also quite high.
Correct.
So we have
Telangana
requested, sir, that it should be brought to now 1:9 at least. Ideally,
Right.
1:6. So we are
Right.
saying that 1:9 is the present demand,
Right.
which will make about 600 posts.
Right.
And they have asked us to submit a proposal. There will be a separate meeting.
Right.
But the only thing is, I cannot predict what the outcome will be.
Can we ask them to have a meeting within 3 months?
I think that not only meeting, a decision, sir. Meeting may happen. Meeting may happen, but decisions are required.
Correct.
So
correct,
if
correct.
positive decisions can be given in 1 or 2 months or 3 months, maybe as sir has said,
Correct.
that may, in fact, in almost all the proposals of the Prison Development Board, if a general direction can be given that within 3 months all the issues should be resolved,
Correct.
I think that will probably help us with the government.
All right. All right.
So the ratio, my lords, the norm is 1:6.
Right. National norm is 1:9 and Odisha is 1:11.
Correct. And prescribed is 1:6.
Correct. Correct.
So Telangana has 1:6. Andhra Pradesh has 1:4. Bengal has 1:8.
Correct.
Gradually, it will be increased.
Decreased.
Gradually, it is in
So these are all good proposals. If a time-bound thing can be done, then
that
it
what Mr. Chabra has proposed, your lordship, and directly government to take a decision on these resolutions of the DPC, that development board meeting. And
So this on e-kiosks, Mr. Chabra,
So
the e-kiosks in jails, the affidavit filed today says 47 are functional, 9 are non-functional. So, and you're proposing to increase it in 33 jails.
yes, sir, we will be buying more. We
Right.
have the funds this year, so we will be covering all the jails this year. Sir.
All
And we have already approached the agency to repair the dysfunctional ones.
All right. All right. You say a detailed affidavit has been filed by the Deputy Inspector General of Prisons explaining the enclosing minutes of the first meeting of the Prisons Development Board (PDB), which was held on 25th July 2022 under the chairmanship of the Chief Secretary to the Government of Orissa, with the participation of other bureaucrats, including the Director General of Prisons, bracket DGP, DG of Prisons, bracket, as member convener. Full stop. In fact, Dr. Manoj Kumar Chabra, the DG of Prisons, is present in virtual mode in today's hearing. Paragraph. The minutes of the meeting reflect the issues addressed. Which include the issue of shortage of doctors, psychiatrists, and nursing orderlies. Full stop. Dr. Chabra has informed the court that an agreement that he has been conveyed the decision of the finance department permitting engaging doctors on a contractual basis on a fixed remuneration of rupees 25,000 per month. And steps will be taken soon to operationalize this proposal. Full stop. On female and male orderlies, permission has been granted for outsourcing. No, for hiring on outsourcing basis. Full stop. As far as manpower shortage is concerned, the minutes of the PDB notes that while the prescribed norm is 1 warder for every 6 inmates in prisons, the national norm is 1:9, whereas in Odisha it is at present 1:11, with the number of posts of warders remaining stagnant since 2010. Full stop. While it has been directed that the PDB will hold a separate meeting for creation of additional posts of wardens and ministerial staff, the court is of the view that a decision in this regard must be taken not later than 3 months from today, and that the next meeting of the PDB itself should be convened for a date before the end of October 2022. Full stop. Likewise, the decision on permitting the hiring of psychiatrists on contractual basis to address the severe shortage experienced by the prisons in Orissa, where the number of visits made either by psychiatrists or medical officers is woefully inadequate, should be conveyed to the DG of prisons within a period of 3 months from today. Full stop. The court would like to emphasize the timeliness of these decisions to address the urgent need for quality medical services in the jails in Odisha. To stop in this context, it is necessary to emphasize the provisions already made in the Odisha Prison Rules 2020, and in particular Rule 797, which reads as under, taking this note, A to A. Mr. Gautam Mishra and amicus curiae has also submitted a convenience note for today's hearing. In which he points out that apart from the above issue of manpower shortage, there are two items which were discussed at the meeting of the PDB which require early resolution. One is the provision of emergency response facilities. Full stop. In this context, Dr. Chabra pointed out that for the 87 prisons in Odisha, there are just 21 vehicles available. 21 ambulance vehicles are available, of which only 6 have been provided by the government. Full stop. This is woefully inadequate by any standard. Full stop. It is directed that in a phased manner, it must be ensured that there is one ambulance per jail provided in Orissa. And to begin with, within the next 3 months, at least 20 vehicles be provided to the prisons department to meet the contingency. The other issue discussed is the corpus fund of the PDB. The court notes that the minutes do not actually set out any roadmap for achieving the minimal corpus fund necessary. This too request to be addressed immediately, and a decision in this regard be conveyed within a period of 3 months from today. On the issue of overcrowding in jails,
I may be just parting. I'm sorry, my lord. My lord just dictated that it's the request of the DG prisons to expedite that. That may be changed to because subject to what the court, what they say, he may be in difficulty because it's a government setup.
All right.
So my lord may take it either as my request or the court's.
All right.
I'm really sorry for this.
No, that's okay. You see,
I think in the initial portion it was.
All right.
Just.
You see but this is really non-adversarial. I think nobody
is,
should be.
I bow down to this, but this is just I don't want to lose.
This is a concern expressed by everyone. That's how it should be actually.
It is, my lord.
You say the issue of overcrowding in jails appears to have improved with only 4 jails at present having a prison population beyond 50% of the overcrowding being beyond 50% in 4 of the jails. And in sub-jail in Jashpur, more than 100%. I think that's what he said.
Yes.
Yes, 105% in Jajpur.
105%. Dr. Chabra nevertheless assures the court that this is receiving the highest priority and concerted efforts will be made to bring down these overcrowding percentages, even in these jails. Full stop. He says that meetings are going to be held with the Police Housing Corporation, which is undertaking the task of building additional capacity for the jails for completion of all the ongoing projects in a time-bound manner. Paragraph. The convenience note highlights the issue of segregation of under trial prisoners from convicted inmates and refers to Rule 320 of the Orissa Prison Rules 2020, which read as under B2B. On the next date, the court will be informed of the steps taken to achieve the actual segregation of young adult inmates from the adults, particularly those in the age group of 18 to 21, in the jails and sub-jails. Full stop. This has already been highlighted by this court in its order dated 21st May 2022. Paragraph. The affidavit filed today refers to the steps taken for installing the e-kiosk system in the jails. Full stop. To begin with, 56 e-kiosk systems appear to have been procured for 33 jails. And in a phased manner, it is proposed to be provided in every jail. Full stop. We issued the directions to the Legal Services Authority for something, right?
Yes, all that has been, I have highlighted the ones which have not been complied. Now, the other one is Joginder Kumar, which was there on 23rd December 2021, para 48. That is yet to be complied fully. What they are doing is they are just giving the numbers. If my lord would see that order dated 23rd December. Paragraph 48, Joginder Kumar's judgment had to be followed. It is at internal page 27, para 48, arbitrary arrests. And specific directions were given for publishing the names of the arresting officers. So this is work in progress. They are doing it. We are following it up in the meetings. So, but still it's 7 months down the line now.
The learned amicus curiae has also drawn attention of the court to the recent judgment of the Supreme Court in Satyendra Kumar Antul versus Central Bureau of Investigation, 2022 SEC Online, SC 825, and in particular the detailed directions issued therein in para 73. The court would expect the authorities, including the DG Prisons and the Orissa State Legal Services Authority, to ensure that these directions are, the awareness of these directions is properly disseminated amongst all concerned and implemented.
Including the Judicial Academy, if that can be added.
Yes, yes. That is already being done, actually.
Yes, yes. Yeah. I'm grateful.
Yeah. I think we'll have it in 3 months' time then.
Yes, after 3 months better.
Soon after we open in, I think 26th.
26th November.
October. Yes. 3 months will take us to October.
Because that meeting your lordship has directed to end of the October, it will be held. So in the November, if the date is fixed, it is better.
No, that meeting actually is, this would be worked out within themselves.
No, this...
well, let me have it in the first week of November.
First week of November is better. 7th,
9th November.
9th.
All right.
The meetings of the implementation committee, that may continue.
Correct.
That will continue. Yes.
In the meanwhile, the implementation committee already constituted by the court will continue to hold its meetings. Thank you, Dr. Jabra.
Sir, if I can take 1 minute, sir.
Yes, please.
Praise you of some, I'm sorry to take a little bit more time. I know the time is very precious, sir. But two developments which have also find mention in the Prison Development Board. One is that we have proposed that a modern state-of-the-art prison management system will be implemented in the prisons.
Right.
During my visits to Tihar Jail and Bhonsi Jail,
right,
and also in Telangana, Cherlapalli Jail, I found that they are the systems which they have adopted there are far advanced than ours. Ours is mostly manual and quite outdated, which leads to allegations of corruptions and lack of transparency. So using the technology, we are proposing actually that some comprehensive prison management system will be adopted. In fact, I wanted it to only 2 jails to begin with, but the government actually is positive and they are saying we will implement it in all the jails in Orissa.
Correct.
Starting with 7 jails as a pilot project.
Right.
So that will use technology to solve a lot of problems, including the problem of sort of medical issues, calling systems, securities, even high security prisoners handling, etc. So I am going to give a detailed proposal shortly to the government, and they have given a lot of positive indication that they are very keen to implement that. That will be a kind of game changer, and prisons will be transformed.
All right.
Secondly, there was another proposal which I have given, and I have found some positive indications in the Prison Development Board also, that Bhubaneswar jail actually is right in the middle of the city, and it is also over capacity. So, and there is no place to expand. So I am proposing a model jail on outskirts of Bhubaneswar, where we can have a kind of signature jail for Orissa, which will have a capacity to handle about 2,500 prisoners, and it will be a kind of model jail where all the infrastructure, modern technology and welfare schemes can be implemented properly, and the present jail can be shifted, and that can become a kind of colony or institute for this. For our jail authorities and prison headquarters also. So these 2 developments, I just wanted to appraise the court. These have actually found a lot of positive resonance in the Prison Development Board. And especially the prison management system, if we are able to implement, this will actually be a game changer for Odisha prisons.
All right. That's very good news. Very good.
I think he missed out. There's one small development, that solar power.
Right.
They want to install solar power on the top of the jail. That's a good environment friendly.
Absolutely. What about those skills development and all that?
Yes, sir. That also that is area. In fact, I also missed out. In fact, most progress has been made in that area only. I have visited the jails, and with skill development department's cooperation, we have already chalked out some projects specific to jails. In fact, I have had meetings with the private sector people, including the Institute of Hotel Management, which is there in Bhubaneswar. We are going to have a bakery unit in Bhubaneswar, which will provide organic kind of bakery. A mustard and masala unit in the Chaudwar jail. And we are planning beauty and hair cutting salons, especially for the female inmates, involving a private chain of beauty salons. They have come up with sponsoring this thing. Similarly, sir, for training for plumbers, electricians, etc., the local ITIs are now going to cooperate with us. And especially the medical issues of the female. In fact, one organization has proposed to give us the sanitary pad making machine. And we can train our lady inmates. It will solve their problem also, and it will supply sanitary pads at a minimal cost to all the prisons. So all these activities are in the works, sir, including starting FM radio station in the jails.
I see.
Entertainment and education. So all these things are work in progress, sir. Maybe within 3 to 6 months, by next meeting, I should be able to report some actual developments on the ground rather than just the proposals.
All right. Very good, sir. Very good. Very good. Thank you.
I'm really grateful to Mr. Chabra and
yes, he's shown the right response. Absolutely,
very much,
very positive. Really appreciate all the efforts being made, Dr. Chabra.
Thank you, sir. It is my team's effort, sir. It's not only me; it's my prison's team, sir.
Right.
And of course, your constant monitoring, sir.
My lord, may I pray that today's order may be communicated to the chief secretary through registry?
Yes.
Lordship may direct the registry to communicate the order to the chief secretary.
The Registrar General will communicate this order to the chief secretary today.
We are all great.
All right. Thank you. Thank you.
Thank you, sir.
Supplementary list item number 25.
Already admitted the question of law. On 21/1/2014.
Right.
That is admitted to consider the question of whether hatcheries are ineligible for the benefits of exemption of incentives under IPR 92, and whether the tribunal was justified in reversing the orders of assessing of the appellate authority without adverting to the aspect.
Right.
Right now, I will take to my notes page is 9 of my revision petition, button Roman 3. In annexure appended to IPR 1992, serial number 3, research follows. In the next page, the following units will not be eligible for incentives as industrial units. Serial number 10. Hatcheries.
Which page are you reading? Sorry.
Page 10 of my revision petition. Item 3.
Yes.
Serial number 10.
Yes.
Hatcheries, piggeries, rabbit or broiler farming.
Right.
Regarding this, the assessing authority in the assessment order containing page 31.
Yes.
Para. Verification of assessment record. Reveals that during the year 1999-2000, the dealer has disclosed the GTO and TTO at such and rupees nil respectively. He has claimed deduction of rupees such towards sale of tax exempted goods and accordingly produced the tax exemption certificates. Since this unit is included at serial number 10, appendix 5, what I previously shown to my alerts of list of ineligible industries under IPR 92 to avail tax incentive, the claim of the dealer is disallowed and the entire turnover is now treated as taxable turnover. In view of the above discussions, the assessment is completed to the best of my judgment. Then my lords, first appeal order.
To cut the time limit, there are 4 petitions filed by them. There are the financial implication on 3 are very minimum. And only the kindly see item number 62. Sorry, petition number 62. Capital tax implication is 7,524.
In 4 years, this is a common order. Common order for 4 years.
That's all. Let me submit. 62, 7,524. 63. 63 is a higher amount, 4,65,000. And one is 54,917. And one is 1,46,000.
Anyway, let's decide it.
Only 4 lakhs. And kindly see the order passed by the the Selters Tribunal. Page 45, madam.
Right.
The issue is, I'll just answer this.
Yes, yes.
Page, I'll come to page 45, running page. The middle, at the middle, whereas the assessment under rule 10.
Yes.
Thereafter the line. Whereas on the other hand, the law and decision appeal of the revenue submitted before this forum that as per the list, hatchery unit is not eligible to get incentive under IPR 92 as per serial number 10 of the appendix 5 of ineligible list of candidates. This is the only contention submitted by the law and decision appeal of the revenue, and he took help of the so-and-so of the reported case between Commissioner of Income Tax, Jagannath Cotton, so-and-so. Perused the said judgment, the Honorable Apex Court found that the matter has been remanded back to the Honorable High Court, Orissa, for a decision afresh in the light of the observation made therein. So no such final finding has been placed before this forum from the side of the revenue. Man, I have brought that judgment, which has been answered by this Honorable Court. On the other hand, the Honorable Counsel for the reported case, so and others and content that as per this judgment, the reopening of the assessment under the rules of CST Odisha rules for change of mind is not justified, and as the industry department of government of Odisha has issued eligibility certificate to the dealer, he is liable to get the benefit accrued under IPR 92. Perud the said judgment of the Honorable Court, wherein their lordship discuss the reported judgment of the Honorable Appeals Court between so and so, we may quote here and the so. Next parameter. As per the impugned orders, both the lower forum series forthcoming that the unit has started commercial production on so and so, as per the certificate issued by the GM DIC Ganjam, Barampur, and the unit is coming under Zone C, is eligible to get tax incentive for 5 years. And there is 60% of the capital investment for the unit. Regarding the reopening of the assessment on the objection of the AG audit, party is not justified as it is a change of mind. In the instant case also, it is forthcoming that because the assessing authority has changed his opinion, basing on the audit report, he cannot call upon the assessee for reassessment under Rule 10 of the CST rules. Further, both the industry department as well as the sales tax department comes under the government of Odisha, and when the industry department invited the entrepreneur to start industry by allowing tax holidays, and accordingly when the entrepreneur started the business by investing huge amount, the said government cannot curtail their benefit by telling that the unity of the dealer comes under ineligible list. So the benefit once accrued under IPR 92 cannot be curtailed by the statute under another act.
No, that's the point.
Yes, no, the point, I'm coming to the point, madam. And he said that we are coming the ineligible group. And I am just filing a memo stating therein that they copy the title. Notification issued by the state government.
Please give him a copy.
Yes, come give him. Mal kindly straight away come to page 2. Page 2 of that.
Yes.
This is 15 July 93. In pursuance to the provisions under Para 2, Part 2, Part 1 of Industrial Policy Resolution, IPR 92, government have been pleased to decide that the activities are listed in the annexure appended hereto will come under following categories of thrust areas for the purpose of receiving priority attention and availing of incentives, concessions under the IPR 92. Number 2 is my lord, marine based. My next page, can you turn to next page, my lord? This is the list of industries. And the last one at page 4, this is marine based. But the name of my industry is not there. Can you come to page 5?
Yes.
Order 7/3/1994, government after careful consideration have been pleased to include the following in the list of marine-based industry as specified in the annexure to industry department or so and so by inserting serial number 10 below serial 9 under item 3, brackish water, prawn culture and prawn hatcheries. And I am entitled for benefits as per this notification at page 2. At page 2 it says that to availing the incentives and concessions under the IPR. I have already been notified. Earlier it was not there. But in 94 by virtue of this notification, and I got the incentive certificate. Kindly come to page 6 in the year 1997 after this notification. And the IPR says on the to get the concession on sale tax, I have to apply. I applied. And after consideration of my candidature, they have issued this. And the page 6, the certificate of eligibility of sales tax concession of raw material, machinery, spare parts.
So this is what is noted by the tribunal.
Yes, notification notified.
No, the tribunal has noted this.
Yes.
My lord, this is prawn hatcheries, those hatcheries. Hatchery has been defined at page number 39 of the first appellate authority. What is hatchery? Here is prawn hatchery.
Yes, mine.
What is submitting is prawn hatchery and marine activities. But hatchery is making chicks from eggs.
No, only that is ineligible then. Then actually you're supporting him. If you say the word hatcheries only refers to poultry, then he's not ineligible then.
Ineligible according to the...
No, he has nothing to do with poultry. He's marine hatchery.
That is the finding of the first appellate authority.
No. We'll have to see what is his actual industry. He's doing a marine-based hatchery.
Yes, that has not been discussed in the tribunal's order.
No. Let's see what he does.
Another thing, my lord, another thing. for the same period under the OST.
No,
OST
the
Act.
Deep Sun, 1 minute. This Deep Sun Hatcheries Limited is in Gopalpur on sea.
Yes.
Gopal. This is a marine hatchery, please.
Yes.
It's not a poultry hatchery, not chicks. It's not a chick farm. Is it a chicks farm?
No. That is the finding of the first appellate authority.
How can it be a finding? Whatever it is, it is. An authority cannot redefine what the business
Yes, my
is.
lord. For the same period in the OST Act, before this division bench order, the tribunal has held is not eligible. That is my annexure 4.
No, but does that order take note of these subsequent notifications?
This order also doesn't take this notification.
No, the dealers' appeals were allowed in part even by that order. The same Deep Sun hatcheries, it's allowed in part.
Part means that exemption part is not allowed.
No, where do you get that?
That exemption part is not allowed.
Let's see that.
If my lords will permit, I'll be placing page 52, running page 52. It is true, the Industrial Policy Resolution 1992 provided certain incentives for prawn hatchery, but in the absence of the notification of the Finance Department to the effect prawn hatchery cannot enjoy any benefit as enumerated in the aforesaid entry. In this regard, the judgment of Honorable Supreme Court in the case of sales tax officer and another versus Sri Durga Oil Mills and another, quoting this, I'm skipping this, then the notification granting exemption under Section 6 of the OST Act specifically declared the hatcheries as ineligible units to enjoy the benefit of exemption as provided in entry number 52 of the tax-free schedule.
No, but which is the year? See, that original ineligibility notification is what date? The latest, this is marine-based being allowed is in July 93. March 1994, it says brackish water prawn culture and prawn hatcheries. Specifically says it's eligible.
Yes, but
no, the earlier notification, the one which simply said hatcheries, is a 1992 notification, I think. This is a 94 notification. So the later notification obviously has to prevail.
Then my lord, I have to go through this.
No, why? This is what is produced in the tribunal also.
No, my lord, nowhere he has...
No. Tribunal discusses it.
Page 46. Running page 46. As per the input order of both the lower forums, it is forthcoming that the unit has started commercial production with effect from 9/3/96 as per the certificate issued by the GMDIC Ganjam Barampur, and the unit is coming under Zone C, is eligible to get tax incentive for 5 years, such as 60% of the capital investment.
No, but the 15th March 2008 order refers to this.
But the notification number is not reflecting.
What did you do on that SA 2115? Did you appeal against it? The 14th March 2008 order? Annexure 4 to the STRE.
Earlier, I was not there.
It is a full bench order. This is a division bench order.
Anyway, that cannot be taken as a precedence.
Not for this court. For this court, it's not a precedent, but we need to find out whether this court has affirmed that order or not. Can you find out?
Yes, I can.
All right. Counsel for the department refers to an order dated 15 March 2008, passed by the tribunal in the SSC's own dealer's own case. For the years 1997-98 to 2000-01, denying the benefit under the IPR 1992 by the order dated, 15 March 2008, SA number 2115 to 2118. Excuse me. The same person is taking, he took the prisons matter. All right. 2115 to 2118 of 2004-05. Mr. Sarangi, appearing for the dealer, states that he needs time for instructions on whether the said order was challenged before this court. He has handed over
a memo. He's added over a compilation of orders issued by the Industries Department exempting prawn hatcheries from sales tax. Counsel for the department states that he needs instructions on the said orders. List on October 17th.
On 17th next week.
No, it's next week.
I have to
Or
take
26th October.
Supplementary list past or matter item number 14.
Milord, this is very sad and unfortunate that the state government under Annex 10 at page 137 has published a list of the disqualified teachers, those who have submitted the fake certificates and the below level mark sheets.
With your lordship's kind permission, I have a preliminary objection. This is a PIL in service matter, my lord.
Correct.
And I have relied on a Supreme Court decision, my lord, wherein, my lord, they have taken note of series of decision and held that a PIL in the service matter is not entertainable, my lord.
Right.
And the other aspect is that all those parties who are going to be affected adversely, they were not party. Only one person has been made party.
18th April 2017. Have you seen that order?
Milord?
18th April 2017. The order passed by this court.
Milord, unfortunately, I have not seen it.
1 minute. We'll help you, sir. We are here only to assist you. All right. Even if you are not able to assist us, we will be ready to assist you. That is our duty. Please, kindly do us the favor of reading it, sir.
Yes, Milord.
Please.
With the lordship's
Lift it.
permission.
No. First, lift it. Keep it on that. Read it. Read it aloud. Read it aloud, sir.
Milord?
Kindly read it aloud.
Yes, Milord. Milord, this writ petition has been filed in the nature of a public interest litigation by 4 petitioners with the primary prayer for a direction to the opposite parties to take immediate steps to remove the disqualified primary school teachers appointed in different primary schools of Jagatsinghpur district from their respective posts. One of such teachers has been arrayed as opposite party number 9. Whereas the prayer made in the writ petition that a large number of such teachers who have been appointed are not qualified. Firstly, it is not known from the perusal of the writ petition as to who the petitioners are, as nothing has been stated in the petition with regard to locus of the petitioners. Secondly, since the matter relates to service of teachers, the writ petition in the nature of PIL would not be maintainable. Thirdly, the selection is said to have been made from the select list of the year 1997. The petitioner have challenged the same after 2 decades in 2017. At this stage, Lord Counsel for the petitioners pray for general adjournment. This is
so. Today also you want to do the same thing, correct?
No.
Please. Sir. See, we have also been in the bar. All right. There are some people who will always take adjournments.
No, Milord.
Top of the hat.
No.
Anything you ask, please give me time. Please give me time for
No. Milord, I beg you,
for that.
Milord, after your lordship's observations, I have collected all the judgments also. I have some judgments also, but a part value was missing. That's why early in the morning,
anything. Today we will grant you anything but an adjournment. Only adjournment we will not grant. Everything else we are prepared. If you want us to hear you, we'll hear you.
Yes, Lord.
If you want to cite a judgment,
Lordship may hear me first.
Yes. We are only, sir, we are dragging you to come and argue. You are the one running away. We only granted Passover. You wanted to go away. So don't now say, please hear me.
Milord,
we have brought you here only to hear you.
Milord, I am lucky and fortunate that I am before your lordship, Milord.
You address these questions first.
Millard, I'm just
Start with PIL and service matters. First, start with
yes, Millard. With your lordship's permission, Millard, this order is not in accordance with my petition, Millard. Because
sir, that you can challenge the Supreme Court.
Yes, no. I'm just pointing out the defects. Let me argue the case, Millard. Let me place the case, Millard.
Sir, first, we are not preventing you from arguing. First, please keep that in mind. We are asking you to argue.
Yes,
we are not preventing you from arguing.
Yes, Millard.
You are hesitant to argue. We actually want you to argue. All right. Let's get that very clear.
Millard.
Second, court has put 3 questions to you. Start answering those questions.
Yes, Millard. Millard, may I begin, Millard?
This is some kind of a game you are playing or what?
Millard, the first thing is that the locus of the petitioners.
Second thing you start, PIL in a service matter.
PIL in a service matter. PIL is not maintainable except in a service matter.
What?
In service matter, a writ of quo warranto, in the form of a writ of quo warranto, PIL is maintainable. I have a judgment. May I be permitted to read? Millard.
Sir, one more thing I want to tell you very clearly now. You don't have to ask permissions for everything you have to do. We are wanting you to argue the matter. So go on asking for permission.
Obligement. Obligement. This is, Millard, this is the judgment of the Honorable Supreme Court of India. That is the case of the Central Electricity Supply Utility of Orissa versus Dhobisau and others. Millard, I am just placing the relevant provisions. Millard. Millard, first of all, directly answering the question of your lordships, there are a number of citations and the court observed that the above principles make it clear that except for a writ of quo warranto, public interest litigation is not maintainable in service matters. Millard.
Then?
Millard, in this case, when it is a service matter, in the form of a writ of quo warranto, PIL is maintainable, and the guiding principles that the principles of law which has been enunciated in the judgment of the University of Mysore versus C.D. Govindarao and another. There are so many series of judgments I have that PIL is maintainable in service matters and in the form of a writ of quo warranto. And in each and every judgment, Millard, what I have found that this judgment, the principles reflected in the judgment that the University of Mysore versus City of Govindarao and another has been reflected. May be permitted. Speaking for the Constitution bench has stated that.
So we don't get copies.
Millard, I bow down, Millard. I will only take very short. Let's place it to tomorrow in the first item or Monday, Millard.
Sorry, I withdraw that question now. You carry on. Carry on. My mistake in asking you that question. Kindly carry on, sir. Kindly carry on. Yes.
Millard, broadly stated, the quo warranto proceedings offers a judicial inquiry in which any person holding an independent substantial public office or franchise or liberty is called upon to show by what right he holds the said office, franchise or liberty. If the inquiry leads to the finding that the holder of the office has no valid title to it, the issue of writ of quo warranto ousts him from that office. In other words, the procedure of quo warranto confers jurisdiction and authority on the judiciary to control executive action in the matter of making appointments to public offices against the relevant statutory provisions. It also protects a citizen from being deprived of public office to which he may have a right. It would thus be seen that if these proceedings are adopted subject to the conditions recognized in that behalf, they tend to protect the public from usurpers of public office. In some cases, persons not entitled to public office may be allowed to occupy them and to continue to hold them as a result of the connivance of the executive or with the active help. And in such cases, if the jurisdiction of the courts to issue writ of quo warranto is properly invoked, the usurpers can be ousted and the person entitled to the post allowed to occupy. It is thus It is thus clear that before a citizen can claim a writ of quo warranto, he must satisfy the court inter alia that the office in question is a public office and is held by a usurper without legal authority, and that necessarily leads to the inquiry as to whether the appointment of the said alleged usurper has been made in accordance with law or not. Milord, para 18. This was I was placing, Milord. Para 15. Para 18, Milord. From the aforesaid exposition of law, it is clear as noonday that the jurisdiction of the High Court, while issuing a writ of quo warranto, is a limited one and can only be issued when the person holding the public office lacks the eligibility criteria or when the appointment is contrary to the statutory rules. That apart, the concept of locus standi, which is strictly applicable to service jurisprudence for the purpose of canvassing the legality or correctness of the action, should not be allowed to have any entry, for such allowance is likely to exceed the limits of quo warranto, which is impermissible. The basic purpose of a writ of quo warranto is to confer jurisdiction on the constitutional courts to see that a public office is not held by an usurper without any legal authority. While dealing with the writ of quo warranto, another aspect has to be kept in view. Sometimes a contention is raised pertaining to doctrine of delay and laches in filing a writ of quo warranto. There is a difference between a personal interest or individual interest on one hand and an interest by a citizen as related to the court or the other. The principle of doctrine of delay and laches should not be allowed any play because persons holding the public office as a usurper and such continuance is to be prevented by the court. The court is required to see that the large public interest and the basic concept pertaining to good governance are not thrown to the winds. Para 19, Milord. Mr. Pipira, Lord Senior Counsel has commended us to the decision in Haribans Lal versus Sahodar Prasad Mahato and others. That is 2010 9 Supreme Court 655, where the Lord judges refer to the principles laid down in Durjodhan Sahu, Dr. versus Jitendra Kumar Misra, that is 1998 7 SCC 273. Ashok Kumar Pandey versus State of West Bengal, that is 2004 3 SCC 349. B. Singh, Dr. versus Union of India, that is 2004 3 SCC 363. Dattraj Nathuji Thaware versus State of Maharashtra, 2005 1 SCC 590. And Gurpal Singh versus State of Punjab, 2005 5 SCC 136, and expressed the view thus: the above principles make it clear that except for a writ of quo warranto, public interest litigation is not maintainable in service matter. Para 21, Milord. As advised, as at present, we may refer to certain authorities in the field in this regard. In Bandhuwa Mukti Morcha versus Union of India, that is year 1984 SC 802, Bhagavati J. Justice, as his lordship then was, has observed us. When the court entertains public interest litigation, it does not do so in a cavilling spirit or in a confrontational mood or with a view to tilting at the executive authority or seeking to usurp it. But its attempt is only to ensure.
So no need to read every line like this, sir.
Milord, there is.
Go on to the next point.
Milord,
yes.
Next point is that, Milord, para 24.
Yes.
In state of Uttaranchal versus Balwant Singh, Chaufal and others, that is 2010 3 SCC 400.
Again, quo warranto. So it's all right.
Is it a writ of quo warranto?
Come to your prayer clause.
Milord, only page 1, Milord.
Come to your prayer clause.
Milord. I have prayed for passing Annex 10, Milord.
Have you asked for quo warranto? Have you asked for issuance of a writ of quo warranto?
Well, that I have not.
So that you have not done. Now come to the next point. What were you doing all these years?
Milord, I'm just directly explaining, Milord. In 1996, there was a resolution of the government for recruitment of the primary school teachers in the district of Jagatpur under Annex 1. Under Annex 2, Milord, in 1997, government published the result. And under Annex 3, Milord, again the government 2006, after the minimum 9 years period, the state government itself published a revised select list on the ground that there has been appointment in those post of primary teachers and so many teachers having fake certificates have been appointed. After 9 years, the government has said that. Milord, after that, I annexed 4 and 5, Milord. In the year 2011, Milord, the Additional Secretary, Department of School and Mass Education, has intimated to all the inspector of schools to remove the primary school teachers who have been appointed on the basis of fake certificates, and this has been also reflected in the letter dated 2014, Milord. Thereafter, this same thing has been reflected in the year 2016, Milord. In the year after obtaining the information in the RTI and when the matter was published in the newspaper, I have filed this writ petition. I have filed in the public interest, Milord, the usurpers of the public office which have been illegally appointed and who do not have a right to the post. I am not seeking any relief from the court for myself, Milord. This matter is simple, Milord. When the state government itself has published a list in the year 2006 that illegal teachers have been appointed, and that is Annex 10, page 137, why the state government itself...
So why did you wait for 10 years to file this writ petition?
Milord, in the 2000...
This list was published in 2006, correct? This list was published in 2006.
Milord, there is last letter is Milord up to 2016 and 17. Milord.
There'll be so many letters like that. This list was published in 2006.
Milord, I'm just placing a letter of 2016 and 17, Milord. When it was, there is a newspaper publication, Milord. I'm just placing. Milord, that is Annex 4 series, page 76. Yeah. I am reading out the letter, Milord. This is the letter of the district education officer, that is to the district project coordinators. And the subject matter is action of allegation relating to submission of fake certificates during appointment. This is the letter dated 5 October 2016, Milord.
Yes.
Sir, inviting a reference to the letter on the subject cited above, the Additional Secretary to Government Department of School and Mass Education Department, Orissa, has intimated that news items are being published. This is the letter of 2016, Milord, being published in different newspapers regarding submission of fake certificates and by the applicants during their appointments under School and Mass Education Department. He has requested to take immediate steps to inquire into the allegations received at your level, affairs against the teachers. And this is the letter of the 2016, Milord.
Yes.
Thereafter, I have applied. I came across newspaper publications, Milord. I have applied through RTI. Right. I have collected the information I have challenged. Right. Milord, this is the matter, Milord. It is within the jurisdiction of the court that the persons, the story of the state government is telltale. When it is, in the one hand, it is publishing a list of teachers who have been appointed illegally by submitting the fake certificates and those have secured below level marks. But till then, the state government has still not removed them. So in this process, if nothing wrong has been done, Milord, if these will be removed, I think that the sin of the society should be at least clear at this stage, Milord.
So in your memo of parties, turn to your memo of parties, the cause title.
Milord.
Please turn to your cause title, sir. Writ petition cause title.
Milord, I know that, Milord.
You know everything, sir. You're all knowing. So what is the answer? So you know the question now.
Milord, I am not, my allegation not against one person, Milord. I am saying that once under Annex 10, the state government has published a list.
Have you made them parties? You have not. Only one of them you have made parties. Correct?
Milord, just one of them I have made
sample, just for sample. Others can go scot.
Milord, I have the information that person is still continuing, Milord.
So you are targeting one person in the name of PIL. You target one person.
No, Milord. That is that if Lordship wants, Lordship may delete it.
This is not about what we want or what we do not want. We are inquiring what you want.
Milord, let them.
How are you selective about one teacher in this whole Orissa? You found only one teacher to make respondent.
Last time also, Lordship, I have a mistake, Milord. I am adding a particular person, but I have not a personal interest against them. I am not praying that person has to be removed. I am saying that all the teachers should be removed, Milord. In respect of the geography.
So nobody should be heard. Everybody should be removed without hearing.
No, Milord. Milord, the state government itself has published the list. Right. That's why I am paying, Milord.
All right.
Milord, what I pray, Milord,
all right.
Let them take the instruction whether those persons whose name reflected in the list have been illegally continuing, are still continuing in service or not, Milord.
All right.
Yes, what is
My lord, so far as this specific person, I do not have instruction. But my lord, series of this fake teacher issue is there, my lord.
Correct.
And series of FIR has been lodged against them and action has been taken against them.
Right.
If your lordship so desires, my lord, I can.
This was my desire, your desire. You
My lord,
answer
the
the question.
statistics, my lord.
He has argued something, you reply to that. That's
My
what
lord,
we're asking you.
is that I have handed over a judgment, my lord. That Supreme Court judgment which says, my lord, in writ petition, my lord, in PIL, my lord, service matter, PIL is not cannot be entertainable, my lord. It should be rejected.
So there again, validity of appointment was challenged.
My lord,
validity of appointment was challenged of contractual teachers.
My lord,
and they said you can't have PIL for that.
Your lordship kindly peruse that. From para 14, my lord, it has been stated.
My lord, we are not praying for ourselves, my lord.
Para 14, your lordship. However, the main argument by the appellants against entertaining WPC number such and such is on the ground that a PIL in service matter is not maintainable. This court is of the opinion that there is considerable merit in that contention. It is the common ground that dispute in this case is over selection and appointment, which is a service matter. My lord, there are in Duryodhan Sahu versus Jitendra Kumar Mishra, a 3-judge bench of this court held that a PIL is not maintainable in service matters. This court, speaking through Srinivasan, just explained that purpose of administrative tribunals.
Give me your judgment, sir. The one you were citing. Give us copy of what you were citing.
In the backdrop of extraordinary jurisdiction of High Court under 226 and 227, this court held that if a public interest litigation at the instance of strangers are allowed to be entertained by the administrative tribunal, the very object of speedy disposal of service matter would be defeated, my lord. Some reasoning applies for here as a public interest litigation as has been filed when the entire dispute relates to selection and appointment. In para 16, it has been said in B. Srinivas Reddy versus Karnataka Urban Water Supply and Drainage Board Employees Association, this court held that in service matter, only the non-appointees can assert the legality of the appointment procedure. 17. This view was very strongly expressed by this court in Dattaraj Nathujit Thaware versus State of Maharashtra by pointing out that despite the decision of Duryodhana Sahu PIL in service matter, continue unabated, this court opened that High Court should throw out such petition in view of the decision in Duryodhan Sahu. Same principle has been reiterated, my lord. My lord, thereafter, your lordship may kindly see, so far as that para 20, my lord, the next point asked by the applicant that they had never been impleaded in the two petition. Even an order passed by the High Court had a direct effect on their livelihood. Also goes to the root of the matter, as it violates the principle of audiatorum pattern. Well, thereafter, their lordship has relied number of judgments on this matter.
With your permission.
And co-warrantor was never a prayer before your lordship, my lord.
This judgment has nothing to do with PIL, sir. Happily citing something which has nothing to do with PIL. What is this?
The response with regard to the submission that co-warrantor is maintainable. Co-warrantor is maintainable.
Co-warrantor is maintainable.
Yes.
But my lord, so far as this selects.
Kindly share a copy with judgment you have relied upon.
See, they will set aside the judgment.
And with your lordship's permission, as it appears, I have to take instruction, but all
even
these
this, even in
appointments
this
are
judgment, they set aside the High Court judgment for entertaining the PL. They set aside the judgment of the High Court for entertaining a PL. Yeah.
The High Court judgment is also with me, Lord. That is
They've set aside the High Court judgment, sir.
obliged.
Orders reserved.
and another aspect, all those appointments are contractual in nature. All those teachers' appointment, because my lord, as per policy, my lord, no direct recruitment to the primary school teacher was there. So all this select list relates to Shiksha Sahayaks. That is contractual in nature.
But are they continuing?
My lord, that I have to take it.
Milord, with your lordship's permission, they have been still continuing in service, and RSCP has been granted to them. And I have gone through so many, because I have gone through so many judgments, Milord, that the judgment which my learned friend is citing, that may be relating to a service matter, that I am eligible and he is not.
No.
But in this case, Milord,
Contractual teachers, same.
This is not a contractual teacher, Milord. They are permanent in nature. They are permanent in nature, and for the
that I have to, because in that list,
and
that has not been stated anything. But my lord, as per policy of the government, my lord, no direct recruitment to the primary school is there, my lord.
Milord, there is a direct recruitment. I have annexed all the documents, Milord, and they have been continuing for the last 15 to 20 years, Milord.
The document which was annexed, the resolution, that is of the year 96, my lord. 96, your lordship may see the first annexure 1, that resolution is of the year of 96.
Anyway, orders reserved.
Yes. Item 21. Item 21, JCRLA 32 of 2007.
Still no one is present.
Sorry?
Still none is appearing.
Yes, ask.
JCRLA 32 of 2007.
Why did he not appear when the matter was called out first?
Sir, I was in the other court, sir. Other court, my lord. Pardon me, sir. Pardon me. Pardon me, my lord.
Carry on, carry on.
In the court of the ad hoc additional sessions judge fast track court, Malkangiri, Agency AJ Devasarma, ad hoc additional sessions judge fast track court, Malkangiri. Date of conclusion of argument 2/11/2006. Date of delivery of judgment 15/11/2006. Criminal trial number 13/2005. City 83/2005 on the file of the additional sessions judge Malkangiri, arising out of GR case number 78/2005, corresponding to the Mathili PS case number 17, date 6/3/2005, committed by SDJ Malkangiri. The state versus Chandra Bhuya, aged about 41 years, son of late Arjun Bhuya. Sukalu Bhuya, aged about 41 years.
What are you doing, madam?
Sorry.
What are you doing?
Judgment.
You're just reading right from the top.
Yes,
In the
yes.
court of the additional sessions judge, you're reading like that. Are you serious
the
about the
judgment-
matter? Have you prepared a note of arguments?
I have prepared, but not satisfaction to convince your lordship.
Where is your note? Where is your note, madam?
Not. I have prepared.
Where is it? Do you know you're dealing with a person's life? Are you aware of that?
Yes.
You did not appear 2 hearings ago, correct?
Yes.
We had to request you to ask people to find you out and bring you to the court. Today again, you have disappeared. Are you
Pardon.
serious about this matter? You are on the panel of the Legal Services Committee.
Yes, yes.
And this is how you prepare. Do you know how many young lawyers are waiting for a chance to argue before a high court?
Pardon me, my lord.
Here we are extending an invitation to come and argue. And you want to fritter away this opportunity.
I pray for next week.
So for this, we have adjourned thrice for you to come and tell us you want an adjournment. Is your client in jail or he's out on bail?
2 accused persons have already died. And 1 accused person is in bail. He is in his house.
Whom are you representing?
Only Shukalu Bhumia is alive and is residing in his house. This is the information I have received from the concerned IAC on 25th March 2021.
The report dated 25th March 2020.
The Secretary, Orissa High Court Legal Services Committee is directed to assign this case forthwith to a lawyer who has at least 15 years experience
in arguing criminal appeals. The complete set of paper books be collected and entrusted to such lawyer, forthwith to enable such lawyer to address arguments on the next date without seeking any adjournment. List on 8th September.
One more pass. Supplemental list passport matter item number 23.
The appellant has been convicted under section 302 and sentence imprisonment for life and 1 year for 309 IPC. The entire case based on
I
circumstances.
don't know. He wanted time to study it. He's finished his argument. You were too.
Here in this case, Item 8 happens to the mother of the appellant. But appellant had gone to his paddy field for harvesting to cut paddy along with his wife, as I'm stated by PW 8.
So the came back, wife was found dead.
Yes,
in the paddy field.
No, he was trying to commit suicide by hanging himself from a tree, and then he was rescued because her mother PW8 arrived there and called the people nearby. They came and caught the rope, and he was rescued. So he survived thereafter. He has been examined as a defense witness, the accused. He has taken a plea of alibi, the accused.
Sir, you're missing the most important fact.
No.
The wife was found dead in the paddy field.
Paddy field loss.
That you're not mentioning. You're depicting the whole case as if it's one of attempted suicide.
That is PW7's evidence. And she was lying dead with caught paddy in her hand.
Yes.
That is PW7. It happened to the brother of the deceased. I saw cut injury on the backside of neck of my sister Hema Dansana. I noticed that she was holding caught paddy crops. And
You better prepare your case, sir. I don't think you're ready with it. Call next Thursday.
It's closed.
Yes, come here. All right.
Supplemental list for admission item number 1, RBI WPET 10 of 2022.
May I please, Your Lordship?
Yes. The Gale matter. That alignment.
Yes, ma'am.
Is the pipeline already laid fully?
Yes, my lord. Pipeline was laid even before the review petition was filed. The writ petition was disposed of on 15th December. The review petition was filed on 24th January. In the meanwhile, 300 meters of pipelines were already laid.
No, is it complete or is it only halfway done?
No, my lord. Actually, this is a pipeline. The length is 110 kilometers, starts from Jajpur to Puri.
Right.
And the pipelines have been laid through these 110 kilometers, except for a small stretch near the Katijodi River. Over the Katijodi River, traversing from Jagatsinghpur to Cuttack district. Otherwise, 30 kilometers long line from the location where this writ petition is concerned, Lakshmi Narayanpur. 30 kilometers till Katijodi, and then from the other side of Katijodi in Jagatsinghpur to Jajpur, 80 kilometers. So this is already done. This has not been charged with gas pending safety audits and certifications.
What has happened to the safety audits?
They are due because of this matter, and otherwise also this Katijodi stretch, once it is connected,
then there will be a safety audit, and then if it is found in order.
You have one more.
I'll just clarify one thing. What transpired on the previous hearings before your lordship. The primary concern was your lordship had been pleased to see the videos that was produced before your lordship, which shows apparently there is a straight route for taking the pipeline by the beyond this residential zone of plotting schemes. And this road where they are saying that they have laid the pipeline, in fact, this road is an internal road of that area, not a approved road of either the municipality or the government. This is an internal road for commutation amongst the plot holders of that particular Om Bihar locality. So had there been no Om Bihar plotting scheme, possibly these roads where they are paying pipeline would not have come into existence. Now, so far as the safety measure is concerned, your lordship was pleased to take note of the fact that though initially the right of user was fixed 20 meters because of lack of availability of space, which they said it is reduced to 10. Then in the rejoinder, when I pointed out that no, it is less than that, they said it is 6 to 8 meters. Now, 1 or 2 houses have come up and your lordship has been pleased to see in the video in the locality, a lot of houses are there. But so far as this one Om Bihar is concerned, though the plottings have been done, only 1 or 2 houses have been constructed, others have not been constructed. Now, the issue is, your lordship, if a construction is made, now there is a prohibition of using anything, machines and other things near a pipeline. Now, this pipeline remains within a zone of 6 meters, that is 3 meters this side and 3 meters that side, though your lordship will find from the statute also, it should be minimum 15 meters. And so far as this, my lord, deep part of it is concerned, that is at which, my lord, depth it should be laid, that I had stated in my affidavit, but they have not adhered to that 2 meters. And if I do not know whether I can make that submission, but if a commission goes also, they will find that it is not exactly the depth at which they have filed affidavit saying that it has been laid in that depth. Because when it was laid, we are all present. So after the disposal of the writ petition, before the review petition could be taken up by your lordship, they have laid, my lord, and they have said it is 300 meters. Your lordship has seen in the, my lord, video that it is apparent that there is a straight line where they can take the pipeline which goes by the side of everything and doesn't disturb anyone. And it's a, my lord, government area where this map was shown to your lordship, my lord, and your lordship was pleased to ask that question. And maybe because of paucity of time, the matter was adjourned. And last date, my friend was suffering from COVID, for which reason the matter was deferred. So this is the background. If your lordship will be kind enough to see the video again, your lordship will see. But for the fact that it was done in a punty scheme, no road was there. It's an internal road. My friend projecting as if it is a road where they are laying, it's not correct. And 2 videos were there. Your lordship may kindly
This is more for his benefit because he was not there last time.
No, it was when it was this video was on. My friend was there.
I've seen it.
I was there.
But unfortunately, on the
next
previous
day.
date, my lord, my friend was diagnosed with COVID.
This is the short video clip of entire length of the internal road of Om Bihar venture, through which the 12-inch high pressure transmission gas pipeline is routed by GAIL India Limited. The width of this internal road is only 6 meters. The pipeline is routed at the center of this road, giving clearance to the plots of both sides only 3 meters. There are total 7 to 8 bends throughout the length of the pipeline within this internal road. The depth of the pipeline from ground level measured while routing was only 1.7 meter, not 2 meter as per the affidavit submitted by GAIL India Limited. Further, at specific measure, there is no RCC slab cover or any protective cover given to the pipeline for the safety of locality, whereas 300 cover should be given all around the pipeline as per para 4.2.5 of Petroleum and Natural Safety Standards. Sir, this is the short video clip of entire length of the internal road of Om Bihar venture, through which the 12-inch high pressure transmission gas pipe.
There is one more video, that map indicating everything. Lordship may kindly see that one.
Honorable High Court's order dated 11th March 2022, a short video clip has been prepared on behalf of review petitioners of Om Bihar for exact location of the pipeline. This is the aerial view of Om Bihar residential project taken from heights. The boundary outline of Om Bihar project surrounded by cultivation land can be seen. Touching the boundary at north side, 180-feet wall canal is passing. Can be seen. The internal roads are developed by the builder to give access to the plot owners and incumbents of the venture. It can be seen many buildings have been constructed and the society is also developing. However, GAIL have already routed the 12-inch high pressure transmission gas pipeline under the internal roads of the society.
Yeah, just pause.
By which
Pause here for a minute. This, where does it come from? That's not clear. This yellow pipeline must be coming from somewhere, no?
The other map, your Lordship will see, thereafter it will be shown. Where it can go, I think from there your Lordship will be able to appreciate.
All right.
At least 60 to 70 plots are falling under hazardous zone. The line is not low pressure distribution line. So
now your Lordship may kindly see.
So it's also cutting across something else.
Yes, then your Lordship will see the next one. That map is also furnished where it could have gone.
It can
affecting
be seen
none.
Many bend points have come up while routing the pipeline. The line routed under the internal road, in fact, is not at 2-meter depth as for affidavit submitted by GAIL, but it is only 1.7 meter, which can be verified. Further, at specific measure, it can be seen that no RCC slab cover or any protective cover.
Now, this is the route, your Lordship.
Given to the pipeline for the safety, whereas 300-meter cover should be given all around the pipeline as per para 4.2.5 of Schedule 1D.
The background is not
Petroleum
background wise
and
is not
Natural
correct.
Safety Standards.
This is the route, my lord, where they could have taken instead of bringing it straight inside. Your Lordship had seen the previous one. I think some defect is there. He had also said about this in the background, but the previous video's voice is coming. This your Lordship can kindly your Lordship may kindly mark. This is going that right hand side, then straight, which is not affecting anyone. From there, that bend, they have brought it straight inside the colony. That is where the problem lies. But the background statement is of the previous.
Carry on.
However, the petitioners have been proposing to divert pipeline through the available route in cultivation land and other side of 80-feet canal as shown in the figure.
So what is your response to this alternative route?
My lord, may I please place a list of dates which will enable my lords to appreciate.
No, that we can do. Is there, do you have instructions on this? Alternate, they're suggesting that alternative route.
My lord, this scheme was floated in the year 2017. By that time, there were no residential plots, and even going by the averments in the writ petition and the representations annexed, it would appear that these were all cultivated land. So when this was planned, when the scheme was planned, the notification was issued, there were no construction, and even the plots were also agricultural in Kisam. So my lord, as I submitted earlier, my lord, this is a 110-kilometer stretch of pipeline, and it is joined, eventually it is joined to become a single pipeline. So 80 kilometers as of today, 80 kilometers from Jajpur to Jagatsinghpur near the bank of Mahanadi is already joined, and 30 kilometers from Lakshmi Narayanpur, where this petitioner's land is located, up to Cuttack district, Sri Samsundarpur on the bank of river Mahanadi, Katjodi, that is joined and laid. So, and even if these pipelines are taken out, though this is 280 meters, it would mean dislodging and realigning the pipeline 2-3 kilometers both before and beyond, after.
Now, why would it be 3 kilometers?
My lord, this is a long stretch. From the video, it would be evident that this is entering through the cultivated lands and then passing through those 280 meters. And then again, there are cultivated lands. The video would show that all around is cultivated land.
Right.
So this pipeline comes through the cultivated land and then it goes.
No, now it's a housing colony.
The housing is subsequent, my lord. My lord, the writ petition was initially filed, my lord, seeking the relief that the homestead land should be excluded. And that is how the realignment was suggested, my lords. My lords may see the list of dates. It will give an overview of the entire, how the matter has progressed.
No, so it's a no. As far as you are concerned, you're not willing to consider this realignment.
My lord, at this stage, it is not possible.
Why?
My
You've
lord,
not really charged the gas line yet. You're
not
still at the
charged,
safety audit
but,
stage.
Realignment would again require, my lord, fresh notification, acquisition. Then there will be feasibility studies, because the route that they are proposing by the side of the canal, my lord, that there is swampy land. It is not feasible. So technical feasibility studies and the procedural formalities.
Can you put down all this in an affidavit? That it's a swampy land, that it's not feasible.
My friend just now beforehand was saying that there is some connection to then made through river. So for which reason it is not complete. Now he says it is going by the side of canal, it is swampy. One more thing I beg to humbly clarify. 2017, the notification came into existence in April. By that time, the land were already converted to Gharabari. That means having the potential of being a homestead in nature, because it's Kisam, your lordship will see, this is in Orissa, page 55, Annex 3 series, the properties of all the residents.
No, let him rule out. I think you
Yes.
file an affidavit.
Yes, my lords.
Saying that there cannot be an alternative. Why you think there can't be an alternative way of taking the pipeline? It's a 280-meter pipeline, correct?
Yes, my lord. That's correct.
So 280
300
meters, shifting it to along the canal, you say is not feasible. Just look at the cost benefit.
I will take instructions, my lord, since this is a technical matter.
You say videos have been played in the court. Videos prepared on behalf of the review petitioners have been played in the court to indicate the exact location of the present pipeline of an extent of 280 meters running across the internal roads of the colony which has come up, residential colony which has come up by the name of Om Vihar. Mr. Samir Mishra, learned counsel appearing for the review petitioners, states that it is possible for the said pipeline to be relayed across the canal abutting the colony without running through the colony in a bended manner.
as it has presently been laid. Full stop. Learned counsel for the Gale, on the other hand, informs the court that between the date of disposal of the writ petition and the filing of the review petition, the pipeline through the colony had already been laid, although it has not yet been subject to safety audit, following which safety audit, full stop, it is only thereafter that it will be only thereafter that gas supply will actually begin through it. Full stop. He states that he will seek instructions on the suggestion of the review petitioners that the pipeline could be relayed across the canal abutting the colony. An affidavit on this, an affidavit in this respect we filed by Gale before the next date of hearing. When should we?
Your Lordship, please, my lord.
We'll file it in 2
He has to
weeks.
file the affidavit.
File it in 2 weeks.
Yes, my lord.
All right. Should we sit on 12th August, Justice Mahapatra? Friday? 12th August.
Yes.
All right. Friday.
Grateful.